Item number 42, we are filing an affidavit. That may be called for. 43, item number 42, we are filing an affidavit. That may be called for.
Listing for RFX 59, 2020.
For what?
Actually, it was been filed and it was been transferred to session court. And then it was been again transferred back because of the plenary jurisdiction.
RFA.
RFA.
Then
So,
has it been admitted?
yeah, so that was the reason. Like, but we'd like to get it for admitted now. We'd like to get it for admitted now.
Admission. Friday.
Please, Lordship. Lordship, I have a CRP, Lordship. It's a matter relating to auto accident, and the insurance company belongs to foreign country, Lordship. So, may listed, Lordship, any date.
Friday.
Hi.
For what?
Nothing.
Hmm.
Then this case, Lordship, is suit has been filed for eviction of the defendant. Accordingly, the suit was dismissed and when the appeal was preferred, it was decreed long back, Lordship. And the title execution case number 6 of 2006.
We are challenging which order?
This order is at page number 33, Lordship.
Huh?
33.
33.
3, Lordship.
Yes. What is this?
On the strength of the petition number such and such filed by Sri Devendra Sahar, stating that the petitioner is not creating any obstruction in the execution of the decree, but the petitioner has reason to believe that through the execution proceeding, the decree holder may occupy some land of the petitioner of state agreement. He is no way connected with the suit, Lordship. So the survey of the decretal land is highly required. The petitioner will sustain irreparable loss and injury if the decree holders are handed over possession of the decretal land in respect of the instant execution case without survey and demarcation of the decretal land. And petitioner is apprehending that the petitioner may got disposes from this remaining portion of the land, which is beyond decree in respect of the instant execution case. Other side has filed written objection on the said petition containing the above two. Said petition is fabricated, intentional and malafide. Peruse the other contention made fairwise in this written objection. This written objection is supported by order of the learned petitioner in India, Learned Civil Judge and Honorable Guwahati High Court. After going through the rival contention, this court finds the execution court will never go beyond the decree. As such, at this point, the time pair of survey and demarcation of the decretal land is not maintainable. However, since both the parties agreed on the same point, the matter of concern regarding measurement of the decretal land, hence assistant of the staff of the circle of the Koringan will fix the issue. Further assistance circle with the execution proceeding will not prejudice the decree holder. So that part is not there because we have filed the objection and the objection is specifically made a mention because the same issue has come up before this honorable court in second appeal also that was dismissed. After that, they filed the application for measurement of the decretal land. So that application we have filed the objection. I have annexed that document also, Lordship. It is at page number 29.
Where?
Page number 29. It was the executing court.
Then?
Page number 29.
Hmm.
In that particular objection, we have made a specific statement. So, if you kindly see paragraph number 4, that the petitioner, Devendra Shah, who has filed a petition under Order 20 and Rule 97 CPC, such and such, entitled execution case number such and such, filed petition number such and such, relying on a registered agreement for sale to a document being number such and such, said petition was already duly adjudicated by the above learned court, and the same is rejected. So, that was already rejected. By the order dated such and such, passed in miscase number such and such, arising out of title execution case number such and such. And in the said order, above learned court opined the third party petitioner in this petition has also taken a stand that the decree holder deliberately did not mention any dag number, khatyan number, or patta number, or name of any muja or porgana in the schedule of the execution petition, and that contrary to the description given for the decretal property, the shop house which the petitioner is occupying is measuring 20.
No, Mr. Chaudhary, what is wrong with this order?
Lordship, because the executing court, because the first time he filed an application on Order 21 Rule 97.
Who filed?
And the respondent, the others, opposite party hearing, he filed an application.
You are the petitioner.
I am the petitioner, I am the decree holder.
Then what happened?
I am the decree holder. Now initially they filed an application that this particular property has been purchased by them, and that was rejected.
And then?
They preferred second appeal. That was also dismissed. Now they file another application. If you kindly see the application.
No, forget about that. Page 33 categorically shows that the court has directed this thing to be carried out.
Exactly, Lordship.
Then what is wrong?
Lordship, If your lordship kindly see the page 34,
And your,
page 34.
Hmm.
Page 33, after going through the rival contention vis-a-vis the court, finds the executing court will never go beyond the decree. So that is the finding.
Hmm.
As such, at this point of time, prayer of survey and demarcation of the decree land is not maintainable. So that has been mentioned. Subsequently, lordship, however, since both the parties agreed on petition on the point that the matter of concern is regarding measurement of the decreed land, hence assistant of the staff of the court, circle of the Korangaji fixed the. So that part is not correct, lordship, because there is a second appeal with regard to same issue.
but the consent is there, your lordship, before the execution.
With regard
court.
to same issue,
Both
there
the parties consented
is-
for the demarcation and measurement of the land.
and there was no such consent on the part of the petitioner, lordship. In the affidavit, objection has been filed on affidavit, stating that this particular thing is to delay the execution of the decree. Decree of 2003.
इसी तो आगे तो रूम की मैं गरम है Now what happened there?
Nothing has happened, lordship. I approached this honorable court. And this
Why?
Because of that particular thing, lordship, because the demarcation, that issue already raised. And that-
Understood.
Yes.
If the demarcation is being carried out, you should have followed it up. You have some problem with the demarcation.
no, that issue has already been stated by this honorable court.
Mr. Counsel, do you have any problem with the demarcation?
Exactly, lordship. That is the reason why I filed the objection. That is the reason why, lordship, I filed the objection, and I have annexed that objection also. It is at page number 29. In that particular objection, we have made a specific and categorical statement with regard to the contention that is the respondent hearing and the opposite party hearing.
Now,
He is no way connected with the decretal land, lordship.
okay, there's no there, but as regards the decree which is to be done, as per the decree, the execution has to be carried out.
Exactly, lordship. Execution has to be carried out.
So let the execution be carried out.
There is the thing, lordship, because what
Now, in
Yes.
doing so,
Yes.
the executive court may take the help of the revenue staff. What is the problem in that?
no, there is no issue with regard to the demarcation of the land, and the person who is claiming that particular
Forget about that person. I'm not concerned with that person.
Yes.
But what is the problem in the court?
Yes.
Taking the help of the revenue staff, more particularly when it is
exactly,
executing the
lordship,
decree.
because the judgment debtor has not raised any issue with regard to that. It is to be by the judgment debtor. Judgment debtor is not before the honorable court. There's a
Why
third
are you
party.
saying that only the judgment debtor, anybody can do under Order 21 Rule 97?
Lordship?
Anybody can do under Order 21 Rule 97?
Yes, he filed an application under Order 2997 that was rejected. He
Then-
preferred an appeal that was also dismissed.
So
Second
what
appeal.
is the problem in the court?
Yes.
Court says that, okay, with the execution of the decree, we'll take the help of the circle officer. What is wrong?
I can understand, lordship. There is no issue with regard to that. But that particular order has been passed based on a person, based on the application of a person who is not at all connected with the suit. He is not the judgment debtor.
Is it required?
Lordship,
At the time of execution, any third party can come?
exactly, lordship. Any
Did he
third
come
party-
earlier?
Lordship.
Did that person come earlier?
Exactly under Order 2097.
For what?
For this particular demarcation of the land. He is saying that I purchased it from the co-owner, and that has been rejected by the learned trial court. And the lower appellate court also rejected. And the second appeal also that upheld this particular
The court is not going to look into those aspects. now.
Exactly,
The
lordship.
court only has said that, okay, we'll take the help of the revenue
No,
staff
that is,
for the
that is
purpose of
based on
doing it.
what, lordship? If lordship kindly see.
Now who
Nothing
is
for-
going to, no, who is going to now show at the time of execution that this is the land? Who is going to show? When it is in respect to dags and patta numbers, who is going to show to the Nazir that they look here, this is the land? It will be the revenue.
Revenue.
What is wrong?
Lordship, this last 4 lines, I'm just coming to these last 4 lines. However, since both the parties agreed on the point that matter of concern is regarding measurement of the decretal land. So where is the question of measurement, lordship? Because the Dagnama Patna, everything is there. Based on that, yes, I can understand revenue staff can demarcate the land and accordingly possession.
No,
can be
when it
handed
is
over.
mentioned out there, hence, since both the parties have agreed on the point of matter of concern, it's a consent order.
No, there was no such consent, lordship, because the objection was there. Objection duly filed by the petitioner hearing, who is the decree holder. That was duly filed. So there was no consent whatsoever with regard to the demarcation of the land, because there is no dispute with regard to demarcation, lordship. Because
What
the
is your
defendant at
problem
any
in-
point of time.
What is the problem in taking out the court taking the help of the revenue staff?
No, I have no issue with regard to
Then-
that. But measurement, all these things, this will complicate the issue. Again, he will find another application to delay. If your lordship kindly direct that this execution is to be done within a short period of time, I have no issue with regard to that. Because the execution
In
of
fact, that
2006,
should have been done at that point of time.
Because
We
the
are in 2024.
execution cases of
You should have got it in the month of July itself.
lordship, the execution case of 2006.
That is why it says, let a copy, report of the Nazir. Report of the Nazir means after the execution, report has to be submitted by the Nazir. You got to stay out here unnecessarily.
No, lordship,
Yes.
no, stay order is not there. We'll fix the issue. We'll fix the issue. There is no issue with regard to that.
No,
because-
I hereby direct.
Yes.
See the order.
Yes,
I
sir.
hereby direct the circle officer to depute his or Elizabeth for his assistance in the execution process in the execution.
Okay.
So, and therefore has fixed it for report, meaning thereby the Nazir will come up and report that you look here, we have executed. That's it. And you got to stay out here unnecessarily.
Lordship, you can understand that thing. But this 4 lines, we fix
I
the
have seen
issue.
that. 4 lines.
There is no,
But this is what it is.
there is no issue with regard to that. With the,
It is unnecessary making it complicated. The court definitely has the power to take the
Yes,
help of the revenue staff.
I'm not disputing that.
Yes.
Lordship. With regard to power, I'm not disputing that. But when arriving at a
Therefore,
conclusion that execution court cannot
This
go
is
beyond
an
the decree.
application under Article 227 of the Constitution. 227 or what?
2 to 7.
Yes. This is an application under Article 227 of the Constitution challenging the order dated 30/6/2023 passed by the learned court of the Munsif number 1, Karimganj, in title execution case number 06/2006. It appears from the materials on record that the petitioner herein are the decree holder. Petitioners or petitioner?
Petitioners, sir.
The petitioners herein are decree holder in title suit number
332.
Huh?
332 of 1992.
332/1992. Pustak. In the said execution proceedings, on the basis of the said decree, an execution proceedings was initiated being title execution case number 6/2006. In the said execution application petition proceeding, an application was filed by the respondent herein
Page 26.
on 28/6/2023, stating inter alia that the respondent is not creating any obstruction in the execution of the decree, but the said respondent had reasons to believe that through the execution proceeding, the decree holder may occupy some land of the petitioner of the said agreement. So the survey of the decreed land is highly required. It was therefore prayed for in the said application by the respondent herein that the learned executing or court should pass necessary order for handing over the possession of the decreed land to the decree holder after proper measurement and survey of the decreed land under the supervision of the court. On the basis of the said, the petitioners herein who were the decree holder submitted an objection to the said application filed by the respondent, stating inter alia that the said application was nothing but just to delay the execution of the decree. It was also mentioned the respondent herein had earlier filed an application under Order 21, Rule 97, 99, 101 of the CPC of the Code of Civil Procedure in the said execution application, which was, however, rejected. It was also stated that against the said order of rejection of the said application under Order 21, Rule 97, an appeal was prepared before the learned civil judge Karimganj, registered as Miss Appeal number 1/2022, which was also rejected with a cost of rupees 5,000. The respondent thereupon did not stop and prepared a regular second appeal before this court, which was registered and numbered as RSA number 60/2023, which was also dismissed by an order dated 7/6/2023. It was therefore the case of the petitioners in the said objection that the said application so filed is nothing but a re-agitation of a matter which has stood already concluded. The learned executing court, upon hearing the parties, rejected the petition filed by the respondent, stating inter alia that the prayer for survey and demarcation of the decretal land is not maintainable at that stage. However, the learned trial court, the learned executing court in the said impugned order observed that the parties have agreed on the point of the matter of concern regarding measurement of the decretal land. And as such, the assistance of the staff of the circle officer Karimganj would be required for the purpose of carrying out the execution, for which the learned court below, learned executing court, directed the circle officer Karimganj to depute his or her eligible staff for assistance in the execution process and fixed the matter for report on 14/7/2023 by the Nazir. Being agreed by the order dated 30/6/2023 passed by the learned executing court, the petitioner, who are the decree holder, have approached this court on the ground that when the application, when the said issue have already been objected to and the petition having been dismissed, the learned court, executing court ought not to have observed that the parties have agreed regarding the measurement of the decretal land and the assistance of the circle officer Karimganj for fixing the issue. I've heard the learned counsels appearing on behalf of both the parties and have given due consideration to their respective submissions. This court is of the opinion that the learned executing court, while executing the decree in respect to a land, is not powerless to take the help of the revenue authorities so that the land, the decretal land, as per the decree, is duly, and so that the possession of the decretal land as per the decree is duly handed over to the decree holder. Under such circumstances, this court is of the opinion that that no interference is required to the impugned order dated 30/9/2023, inasmuch as the perusal of the said order only shows that the learned executing court had only asked the assistance of a staff of the in the office of the circle officer Karimganj, so that the execution process could be carried out. Accordingly, this court finds no merit in the instant petition, for which the petition stands dismissed. Before concluding, this court finds it relevant to observe and direct that the learned executing court shall carry out the execution in terms with the decree, and the assistance of the revenue authority may be taken by the learned executing court. The said assistance should be only limited to the assist the owner as limited to showing the boundaries of the decretal land and nothing further. Previous stands the judge. Yes, madam. You want the transfer from where to where?
I go to Silchar Road.
Where both of you were staying earlier?
Both of I joined. Subsequently, she was deserted by the husband. Lordship.
Huh?
She was deserted by her husband, and she stayed for few days in Badarpur in under Karimganj district, and subsequently now she is living with her one of the relatives at Silchar, Lordship.
So that is not permanent.
Permanent because now she is homeless.
Because if we transfer it to Silchar tomorrow, then tomorrow, day after, you will say that no, I don't want to stay in Silchar now.
No, Lordship, because that lady is her relative. Now,
So the relative may not be there.
otherwise it is very impossible for her to go to Aijal due to the threat perception. And
Why? What is the threat perception?
she went there on August 28th to live with her husband, but she was tortured
By?
by her husband, and he locked the room of the house and came out. Subsequently, he has filed that application for divorce
Where is the FIR file?
in Aijal Road.
Then? Go there.
At that time, she was there. That is why immediately she had
So last resided at Aizol.
that.
Last resided at Aizol.
No, Lordship, she was living at Badarpur.
So why is the husband staying in Aizol?
He worked there. He's working there.
He's a permanent resident of where?
Sitsagar, Lordship. Sitsagar.
Why have you not mentioned that in your petition?
He has in his petition he has not mentioned. Lord.
Forget about he saying you are asking for transfer. Why haven't you mentioned that?
I have
That
not
he is
mentioned.
temporarily residing at Aizol for his work, nothing more than that.
He also in his application he stated about that I am working at Aijal.
Where?
Lordship, the marriage of the petitioner, page number 13. Page number 13.
You
paragraph
married
4.
out there in Aizol.
Yes, marriage is at Aizol,
You
Lordship.
stayed
In
together at
April.
Aizol.
Yes, Lordship. Subsequently, she left. He himself stated in his petition that after marriage, petitioner repays it to respondent. Is it the hometown in Tinsukia, Lordship? That Asif record. And 10 years baby with 10 months baby with several ailments. Paragraph 14, he stated that his earning his livelihood at Aizol. There is no other source of income to go to Aizol, and with 10 months baby that has been suffering from several diseases, Lordship.
There's a divorce petition.
Yes, filed by the petitioner.
Then what happened on 23/1? You appeared.
No, Lordship. Some other person took time. He could not appear free.
No. Issue notice making it returnable on 10th of April 2024. The petitioner is directed to take steps by way of registered as well as usual. The petitioner is further directed to take steps by way of dusty rooted to the registry of the spot and file an affidavit of service on or before the next day. The case of the petitioner herein is that the petitioner and the respondent were married on 18/4/2022 at Aizol, Missouri. And they started to live their marital life at Aizol, Missouri. However, on account of some matrimonial feud, the petitioner is presently staying at where the petitioner started to stay at her paternal home, that is at Karimganj, and is presently staying at Silsha. However, the petitioner received a summons in connection with divorce petition number 149/2023, pending in before the court of the additional district judge, Aizol, Judicial District, Aizol. To the said summons, a divorce petition have been enclosed, filed by the respondent under section 13(1)(1)(a) of the Hindu Marriage Act 1955. It is the case of the petitioner that the petitioner is not in a position to travel to Aizawl. As she has a 10-month-old daughter, as well as. And what are you doing? What are you doing?
No, no, sir. Nothing.
And you are staying with somebody else, as well as the petitioner does not have the financial resources. Taking into account the above, this court stays the further proceedings of divorce petition case number so and so 149/2023 pending before the Court of the Learned Additional District Judge Aizawl, Judicial District Aizawl, Mizoram, till the next date.
All right.
Yes,
Application. Petitioner file is petition to transfer a title suit for restitution of conjugal right from Bilasipara Dhupri to Kamrup Metro Guwahati.
Huh?
From Bilasipara Dhupri to Kamrup Metro Guwahati. Petitioner is a 5-year boy, my lord, who is suffering from 65% disability. My lord.
how much disability?
65%.
Petitioner.
Petitioner boy, 5.
Obviously, petitioner is the wife.
Yes.
Who is suffering from?
Petitioner 5.
Show me that certificate.
Yes. Page 11, my lord.
Petitioners
Page 11.
who is suffering from 65%?
Petitioner boy, my child.
Petitioner's boy.
The child. 5 years.
Issue notice making it returnable by 22/4/2024. The petitioner is directed to take steps upon the respondent by way of registered as well as usual. Further to that, the petitioner within 3 days. Further to that, the petitioner is also directed to take service upon the respondent by way of the state routed to the registry of the court and file an affidavit of service on or before the next stage. This is an application under section 24 for transfer of TS bracket R number 83/2023 from the court of the Munsif at Bilasipara to the court of the principal judge, to the court of a competent jurisdiction in the district of Kamrup Metro. How is the Munsif taking up this matter? This court have duly taken note of.
There is no family court.
Huh?
In Bilasipara, there is no family.
Understood. How can the Munsif take up an application under section 10? Where is the take on Hindu marriage?
They file under order 7.
Huh?
So written that petition file under order 7, rule 14. Page 13.
Huh?
Page 13 of it.
Is the petition under?
Under order 7.
Mr. Counsel, if you don't know, don't say all these things. This court having taken note of section 19 of the Hindu Marriage Act 1955. Oh, this is, yeah, na? Oh, this is not under the Hindu Marriage Act. This restitution of conjugal rights as per the Muslim law is done under what provision? It's merely a suit.
Mile.
It is the specific statement of the petitioner. The petitioner is resided at Guwahati, and with her petitioner, with the petitioner. But you don't need to appear. You can engage a lawyer.
Family matters, my lord, day-to-day appearance is required.
Why?
Required.
No. Why is it required? It is a suit.
My lord.
Then
Family matter is
no, it is a suit. Here it has to be transferred to here again in the trial court.
petitioner already filed in maintenance case before the family court, which is pending the before the family court number 3, man. Maintenance.
Before?
Maintenance 120 under section 125.
This is an application under section 24 of the Code of Civil Procedure 1908 for transfer of TSR number 83 of 2023 from the court of the Munsif at Vilasipara to the court of a competent jurisdiction and of Kamrup Metro. It is the specific case of the petitioner that the petitioner is residing at Guwahati along with a 4-year-old child who suffers from 65% disability. And as it is also the case of the petitioner that what are you doing?
How to apply, depending upon my
The petitioner does not have the financial resources for participating in the trial of the said proceedings. In addition to that, it has also been mentioned that the petitioner had also lodged proceedings under section 125 of the CRPC before the learned principal judge family court Kamrup Metro at Guwahati, which have been registered and numbered as FC CRL dot bracket close 689 of 2023, which is pending before the court of the principal judge family court number 3 Kamrup Metro at Guwahati. Taking into account above, this court states the further proceedings of title suit bracket R number 83 of 2023 pending before the court of the Munsif at Vilasipara till the next stage.
Black.
Yes, what is this?
May I please, Your Lordship, before my learned senior friend begins, my lord, we had filed a caveat in this petition, my lord.
You have got a copy?
I have got the copy.
You have got a copy of the petition?
No, my lord.
No, no, given.
Well,
Why?
Somebody does not
They
attach
have
my
filed the previous subsequently, will serve a copy.
What is this challenging?
Order passed by the executive.
When did you file?
on 13/3.
When was the petition filed?
Petition, our petition was filed
27/2.
February 27.
27/2, and it was registered on 15/3, my lord. As per the case status.
Okay, what are you challenging?
Well, I'm challenging an order passed by the executive court whereby I've been asked to pay money beyond the decree and beyond the terms of that good fixing judgment when you brought me today. I'll show you. Lord.
Beyond the?
Beyond the terms of the decree. And the trial court judgment start from page 35. Lordship may kindly turn to page 66.
Page 35.
Start from page 35.
You have an extra copy? Give it to him.
Lordship may kindly turn to page 66.
Yes.
Order.
What is the decree passed? Decree?
Trial court decreed the suit, my lord.
Wait, let us see here. In the result, the suit is decreed in favor of the plaintiff on contest with the cost for recovery
of rupees
of
2
rupees
crore
2 crores 26 lakhs 75,000 and so on.
from the
Along
defendant
with
along with
further
usual
interest of
interest
2%
above the bank lending as per
rate
IRDA,
as per
which is to be
IRDA,
calculated as
which
per
is to be
bank norm
calculated
as
as
on
per the
today.
bank norm as on the decretal amount per annum with effect from the date of institution of the suit, till full and final decretal amount. Okay, then
Now, Lordship may kindly turn to the execution petition that they have filed
have you filed an appeal?
against this. No, appeal was in respect of different matter. I'll come to that. In respect of the interest calculation, my lord, against this decree, appeal was filed by us. It was partly allowed in respect of the logs which were destroyed in the fire.
How much is the decree? Where is the appellate order?
There was no difference in the amount. My lord, this part.
RFA is there.
RF is there. I will.
Let us see what is the order.
It starts from page 72.
Where is the relevant part?
Page 118, para 55.
Okay.
118.
In view of the above, it is appeal stands partly allowed. The plaintiff file is entitled to the insurance claim amount covered by exhibit for the rejection. The claim relates to 415. Payable to the plaintiff under the decree would therefore be computed on the basis of 415 only. What is this? How much? Earlier it has been quantified. The judge did not quantify.
It is.
There the problem arises.
No, that quantification we are not disputing.
Huh?
That quantification we
So
are
what
not,
is the amount?
it comes to around, according to us, 25 lakh 16,305.
Huh?
Yes.
Earlier it was 2 crores.
Well,
Now this has been reduced.
it was because the logs were 2850, 2,850. It has come down to 415 by the Supreme Court. Logs have been brought down to 415 logs only. That calculation logs will find at page 23, man. In
Page?
Page 23 in the execution petition. With regard to the logs, number of logs, there is no dispute. Another party is disputed.
26.
Page 23, man. In the execution
Then?
petition. Lord has got page 23, my lord. On
Hmm.
top, Lord you can see value of 2850 number logs and so. A value of 414, which was modified by the Supreme Court. Number of logs, it comes to 24 lakhs 16,305.
As regards the other amounts you have paid.
Yeah, we have paid some amount. I am coming to that. 4 installments we have paid. Actually, kindly see second serial number 2, 414 number of logs. Now value is this much. It comes to 24 lakhs 16,305. No problem. Claim for staff quarters 1 lakh was granted. There is also no difficulty. Total comes to 25 lakhs 16,000. No difficulty. Now 5 and 6 there is difficulty.
And what is the value of 2850 blocks?
1 crore 66 lakhs. That they are not paying because this court is modified. They have gone to Supreme Court. It's pending.
Supreme Court did not state.
No, Supreme Court said that the pendency of the SLP will not debar them to claim the amount which this court has granted. Page 122, Lord kindly.
So as per the appellate court,
My lord.
in view of that what has been discussed above, this appeal stands partly allowed.
Yeah.
The plaintiff firm is entitled to the insurance claim amount covered under policy number to the extent the same relates to 414 numbers of log. So that is the only amount they are entitled to.
Exactly. So far as
The
interest is
amount
concerned,
payable to the plaintiff under the decree would therefore be computed on the basis of 414 numbers of logs only. The judgment and decrees would stand modified to the above extent.
yes. So far as interest part is concerned, trial court's decree still prevails. That I have shown at page 66. It has to be 2% above the bank rate, number one.
As on
Secondly-
that date.
Yes, my lord, that is the problem. Now, in the execution petition, they have claimed from the date of fire. This Honorable Court said from the date of petition, they claim from the date of fire. And around 8 lakhs on that they have calculated. Lord, you kindly see at page 23, serial number 5 and 6. Rate of interest upon decretable amount from the date of fire till date.
Where is the trial court judgment again?
Trial court judgment of page 66, man.
The
It is
defendant
clear
along
from
with
the date of
further
institution of
interest
this suit.
at the rate of 2% above the banking rate as per ITA would be calculated as per the bank norm as
Just
on
so far as-
that is 7/3/2013 on the decretal per annum would effect from date of institution of the suit. No, the interest will be calculated as on 7/3/2013,
Yes,
but it would be payable from the date of institution of the suit.
exactly, my lord. That is
So
our
that is
case, my lord.
13/3/2003.
Exactly, my lord. Now, in the before the executing court, they have claimed from the date of fire. And that was granted. This is one objection we have, my lord.
So you are therefore asking not 18%. This has not been granted. Number 5 is not granted, but
Yes.
number 6 is being granted.
No,
Number 6 is also not there.
not there. 5 and 6 are not there. And so far as 8 and 9 are concerned, my lord, with regard to interest, Lord, you kindly see, they have claimed 14.45% and 2% to be added, 16.45%. My lord, this honorable court said 2% above the bank lending rate. There is some confusion, my lord. If we go by the bank lending rate, it will be different. IRDA norms, again, this honorable court said it will be different. If we go by IRDA rate, it will be 6%. At that time, bank rate was 6.25%. 2% will be added, it will be 8.25%. Now we have made separate calculation on the basis of 8.25%.
How much?
And we'll hand over the sheet man we have prepared. And in between, 4 times we have paid. First 15 lakhs, that my lord, will find 30. Lordship, we have prepared one chart annexed here, page 156, Lord will find. Type copy as page 156. Principal amount as per judgment in degree is modified by the Honorable Court on 414 blocks, 24 lakhs and odd. Staff quarter 1 lakh, total 25 lakh. Amount paid on 6/9/13 we paid 15 lakhs. On 3/1/2020 we paid 6.53 lakhs. On 3/1/2020 again 25 lakhs 14,000. Now interest we have calculated from 13/3, that is the date of petition, to 6/9/13 on so at the rate of 6.25% plus 2%, that is 8.25%, it comes to 21 lakhs. Interest from 7/9/13, because on that date a payment was made, to 3/1/20, it comes to 5 lakhs something. Then from 4/1/20 to 18/11/21,
Wait. You have calculated wrongly. Because
My lord.
first you have to,
We have made separate calculation on the basis of goodwill.
first it has to go against the interest, cost,
Second cost,
interest, cost, then the principal.
then my lord, I have
Where is
seen the judgment and your lordship subsequent judgment also.
Yeah. No, because unless 60 says something.
My lord,
it has-
unless the decree appellate court says something.
So as per you now, this 17,30,000 is payable.
Right.
Principal amount as per demand is demand, staff quarters is 1 lakh, subtotal 25 lakh, interest from so and so to so and so.
My lord, I have
Demand from one is 21 lakh so and so. Total is demand, part paid demand, then 31 lakh. No, this is again wrong. You see, the interest can only be on the principal. There cannot be an interest on
on
interest.
interest, yes. That is why they will, there's one.
This is also wrong.
Yes, my lord. Interest, there can be.
In
interest
fact,
on
you
interest.
don't make the calculation in
Well,
this manner.
I-
First, you have to put the date,
Yes.
then you have to put
It
the principal, and then the interest.
My lord,
And then you have to subtract from the principal.
But
Just for example, this 21 lakhs was the amount. you minus this 15 lakhs comes to, then you don't make it 46.
My lord, there is some mistake.
You
I
have
think.
to make it 4,16,000.
I-
Then again have the interest from so and so calculated from there.
My lord, I-
This is not how it is done.
My lord, I-
Do it properly. We'll have it on Wednesday.
My lord, Mr. will be appearing in this matter. He is indisposed.
Huh?
Maybe on Friday, my lord.
Friday, Friday.
Absolutely no.
Well,
It is
fine.
his case.
My lord, let us have it on Friday. I put some things to do.
Make this calculation because
Madam,
that
we'll
is
take-
how the calculation, this
Madam.
calculation.
It has to be remade.
List the matter at the request of the learned counsel for the petitioner. List the matter on Friday. Mr. B. Prasad appears on behalf of the caveator
So
and
this-
have accepted the copy of the revision application. The name of Mr. B. Prasad is shown in the copies.
the caveat petition may be tagged with, my lord. Caveat petition. The
Why do you
Wakalatama is
want?
there, my lord.
It's something,
The
does it look
Wakalatama is there.
nice? I put your name.
My-
What unnecessary
My
don't make
lord.
those.
I'm extremely sorry. Bye-bye.
Can I have the chart? I'll read it.
Take it, because this is wrong.
My lord.
There is one judgment where I have done it very properly.
I've seen that. Nijara Goswami.
Huh?
Nijara Goswami.
Yeah,
have done it.
something. I made it very properly.
I have done that.
The calculation, how you have to.
Yes.
So therefore, this 25 lakhs, if you have arrived there, then you minus it by 21 lakhs. After that, 5 lakhs or 4 lakhs remain, the 4 lakhs remains intact. Then on that amount, principal amount, thereafter, whatever again the interest accrues. The interest accrues, then this interest is again has to be brought in this column. And then again subtracted with the amount which have been paid. After that amount, again, if any amount is there, if it goes beyond this, then you have to put again subtract it from the principal amount.
I'll do that.
Yes.
Wait.
What is this?
We are the defendant opposite party. I think it's
What
right,
order?
my lord,
Which order?
Learned Munchi.
Which
Yes,
order you are challenging?
Well, the order granting ad interim injunction passed by the Munchi Civil Judge Junior Division.
Where?
At page, my lord.
Huh?
Yes, my lord. At page 22. Passed by the learned Munchi, my lord. And
22.
yes,
Then
then my lord, page relevant portion.
you
from-
filed appeal?
Yes, preferred an appeal.
What happened?
And my lord, that was also rejected.
Where is the appeal?
Page 26.
20?
Page 26. Well,
20?
this order 43 rule 1 and 2 under section
26.
Well, they are possessors of this plot of land. And
What is
they-
the order passed?
Here, my lord. Because they
Appeal is-
have challenged. Because they are.
What are you asking for? Title suit for declaration of right title and interest of Schedule A and recovery of first
By the
possession in Schedule B and confirmation of possession in Schedule C.
Yes.
On receiving the petition for injunction dated one accordingly the opposite party in this case.
Which are held upon notary, my lord. Power of attorney, which is notarized only. This plaintiff has filed this suit. my lord.
So there is a restraint by the trial court
Yes, my lord.
and the appeal has been dismissed.
Yes.
Then what is wrong?
Page 29, my lord, because they are possessor. All these possessors are not party. All the possessors are not party. Some of the possessors are, my lord, party, but they are, my lord, celebrating puja, Tarak puja since 1963, my lord. At page 29, lord, if may kindly peruse 6,
Hmm.
ground number 6,
Page 29?
29. Ground
Yeah.
number that the balance of income in favor of the appellants as they are possessing the land since 1960 without any break, with knowledge of the owner. That much irreparable cause is so and so. the appellants and villagers, people, thousands of villagers has been possessing the suit land and performing Sarak Puja. All these Sarak Puja and Mela, and they are planted littleness and they are not a party in this title suit. But now only this restriction, because of this restriction, this Puja is to be celebrated in the month of April, next month. So there may be some law and order situation.
Where is the plane? Where is the plane?
Plain, I have not explained, my lord.
This is not how, man. No, Mr.
Yes,
Goswami, this is not how you do it. You have to bring
I
before
am
this
opposing
court.
party. My lord, this first Munshi, the ex parte order was passed because.
No, this is an inter-party order. This is an inter-party order.
Yes, but my lord, no ex parte order.
This
Yeah.
one,
First Munshi order is ex parte.
22.
Yes, yes. Ex parte order because they could not file the objection due to COVID situation, my lord, at that time. Because the opposite parties you have to sign the my lord, objection. They could not come. Therefore, my lord, this ex parte order was passed. Against that order,
Then ex parte, why didn't you move under order 39 rule 4?
some committed some mistake, my lord, but
Then?
they have filed this order 43 rule petition, my lord.
Then,
My lord, I have suggested, my lord, to file this to vacate or ex parte order, but they have filed this order 43 rule 1 and 2 petition, my lord.
then,
Now, lordship, if the Munship is, my lord, allowed to file objection and hear the entire matter afresh, my lord, both the parties will, my lord, get justice, my lord, because the Sarak Puja has been performing since 1963, my lord, more than about 60 years, my lord. And they are tribal people under tribal bill, this area, and their my lord, land is under tribal bill. So, my lord, the sale took place.
Mr. Goswami, without seeing the plaint, I am not in a position to say anything in your favor. This is a case to be dismissed right away. You had the chance earlier also. Because if I issue notice, I can only issue notice today. Nothing more than that. But I don't know who are the parties in the suit, who are the parties in the respondent. Because that is a very relevant issue.
Well, this,
Who are you?
the petitioners are the my lord, defendant, opposite party. They are 13.
And therefore, it is without the plaint, it is not. Are you all parties in the suit?
Yes, my lord.
Huh?
Yes.
There. So this opposite party will be only these. You have a right. What is the injunction passed? Not to
Right.
disturb the opposite party's hearing, restrain from entering the Schedule C land
Yes,
and
yes.
from changing the nature and character of the Schedule B land. So you are in Schedule B.
Yes.
You are not in Schedule C.
Well, the Schedule C also included in Schedule B land, and we are performing.
So how do I know?
Puja.
No, how do I know? Where is the plaint? We dismiss it on that ground. Having not enclosed the plaint. I don't find it good case for
Plaintiff resides
issuance.
in Rajasthan. Plaintiff is from Rajasthan. He is not.
I cannot say whether he is from Rajasthan. Where is the plaint?
Well, at page 13.
No.
Order.
I'm not concerned with that. Where is the plaint? Where is the injunction application? This is not how you file it. The petitioner hearing submits that you want to withdraw with liberty and file a proper one.
Well, then time limit. Because because in the next month.
So why have you approached now? When the order was passed then,
We have
and you have the, and on the last occasion on 2/2/2024, you have asked for time. Then you are not interested in the matter and you are saying all these things.
Well, you have filed in 20 December.
This order is passed on 1st of September 2023 and you are sleeping over it. No. I'll dismiss it on merits then.
No, my lord,
This-
then issue notice only. Issue notice.
Absolutely no. I
I
don't
understand.
want to, no, I don't issue no. Don't make.
My lord,
This is an application file under Article 227 of the Constitution, challenging the order dated 1/9/2023, passed in Miss Appeal number 4/2022, whereby the learned First Appellate Court had dismissed this appeal filed by the petitioners, thereby affirming the order dated 3/5/2021, passed in Ms. J case number 36/2019, arising out of title suit number 64/2019. Pusto. This court finds it relevant to observe that in the instant application, the petitioners have not endorsed the copy of the claim, the copy of the injunction application, as well as the proceedings before the learned First Appellate Court. This court have also taken note of that the said injunction order which have been passed this court further takes note of that the trial court passed the injunction order on 3/5/2021, and thereupon the appellate court passed the order on
1/9/2023.
1/9/2023. The petitioners thereupon have only approached this court by filing the petition on 20/12/2023. As of date, under such circumstances, this court therefore is not inclined to interfere with the exercise of the equitable jurisdiction by the trial court, which have been confirmed by the learned First Appellate Court. More so in view of the fact that no perversity could be shown to the said orders. Consequently, the instant petition stands dismissed with cost of
Now, my lord, I'm
Cost-
allowed to file this.
No.
But to-
matters in.
Because my lord.
I asked you
public
that.
interest is-
No, miss, there is no public interest
is
element.
my lord.
If you are public interest element, then who are you? Therefore, how do I know who are you? That is why I told you. And don't, Mr. Goswami, kindly don't treat this court that this court is going to issue notice. Issuance of a notice in this court is in a writ I don't do. Forget about these. You want to withdraw, I can give you the liberty to withdraw with liberty to file. Mr. R. Goswami, the learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant application, taking into account that the necessary pleadings before the learned trial court as well as the First Appellate Court have not been placed on record. Taking into account the above, this court permits the withdrawal of the instant petition. However, liberty is given to the petitioner to refile, provided the pleadings before the trial court as well as the First Appellate Court is brought on record.
Public.
Yes.
My lord, I have filed one suit against the respondent for specific performance of contract, wherein before filing of the suit, I have purchased the stamp duty and prepared a demand draft and the banker's checks. And
Who are you?
I'm the plaintiff petitioner.
You are the plaintiff.
Petitioner.
Plaintiff.
Plaintiff.
You filed a suit for?
Yes, especially performance of content.
Okay, where, what is the impugned order?
Impugned order at page 61.
Okay, what is that?
I have filed one application for
Plaintiff has entered
and
into the
yes, of
suit
the-
and engaged an human and 6 times for filing Wakaratnama and WS. Hired payer along with the petition with the payer to permit the payer to initiate refund process of the said e-stamp, registration fee and to cancel the banker's check as detailed in paragraph. 155. Now, what is it?
My lord, I have filed an application that stating that the e-stamp which I have purchased in order to register the sale deed, because the respondent is not registering the sale deed, and the banker's check and the demand draft which is prepared to pay the balance consideration amount.
Where is the e-stamp?
E-stamp
Page 27,
24.
27. This is a challan. And this e-stamp is valid for a particular period of time?
Particularly for 6 months. For 6 months only.
How do you know?
Because any stamp purchased if does not utilize within 6 months, if in case of refund, there is 6 month period only.
Then banker check is what?
Banker's check for the in respect to the payment of the balance consideration amount.
20,000
No, madam.
and 53 lakh.
Yes, madam.
Now you want to return it.
53 lakhs and
Where is your petition?
petition is at page 57.
Where is it? Purchase the stamp of. When did you purchase?
Have purchased. Your Honor,
E-stamp purchase on?
purchase.
Your banker check has already become invalid.
Invalid. That's
No.
why I no use to remain in the my money is
So with that, you can get the money back.
yes. Ma'am. And for each stamp if I cancelled, 10% will be deducted.
We do one thing.
Each stamp purchase on 6 November.
No, we do one thing. When is the next date fixed?
Next is on 28
20.
in this month, 28 to 8.
28, no? We dispose of this petition. Directing the court to take into consideration that and pass appropriate orders taking into account that keeping the check as well as all these things would cause further loss to the petitioner. And as such, while recording that, may pass appropriate orders so that it can be. I think that is a better option.
Right.
Because issuance of notice out there, he did not have anything to say out there. So it is the court who have done it. The court have made it wrongly. And then on that date, you can very well show it in the court and the other side cannot have a say out there.
I have I had
Because
said-
then if I pass an order to that effect, other side being not here now, it would be wrong. So I set aside this order. This order does not affect them, but you will again re-agitate the aspect. Chal. This is an application under Article 227 of the Constitution challenging the order dated 2/2024 to the extent of the order passed by the learned trial court, that is the Court of the Civil Judge Senior Division number 2, Kamrup Metro at Guwahati, in connection with petition number 459/24. Full stop. Taking into account that the application, the instant application requires urgent disposal and the presence of the respondent being not required, this court takes up the instant proceedings for disposal at the motion stage. The case of the petitioner herein is that the petitioner filed the suit. Where's the plaintiff? Filed the suit, being title suit number 773/2023 before the Court of the Civil Judge Senior Division number 1, Kamrup Metro at Guwahati, which was subsequently endorsed to the Court of the Civil Judge Senior Division number 2, Kamrup Metro at Guwahati for disposal. The said suit was filed seeking specific performance of the deed of agreement for sale dated 29/5/2023, which was registered bearing deed number 11329/2023, executed between the plaintiff and the defendant. In order to show the plaintiff, prior to the filing of the said suit, had purchased e-stamps for the execution of the deed of sale bearing certificate number IN AS61-256535284405V of rupees 3,41,000 and had also deposited the registration fee of rupees 2,05,600 by e-challan bearing number GRN gap AS005056002023224P on 6/11/2023. In addition to that, the petitioner had also prepared three banker checks in the name of the defendant bearing number 175182 dated 7/11/2023 for rupees 20,000 from the Union Bank of India, Moidam Gaon branch. B. I got to A into B. Banker check number 526852 dated 14/11/2023 for rupees 53 lakhs drawn on from Indian Bank, Beltola branch. And C. Banker check number 175199 dated 18/11/2023 bearing for rupees 2,50,000 drawn on Union Bank of India, Moidamgaon branch and had also drawn one personal check dated 14/11/2023 for rupees 1,30,000. Full stop. Taking into account that the said e-stamps are required to be used within a period of 6 months, and if a refund is sought, taking into account that the period of refund of the e-stamp and the registration fee with deduction of 10% of the value is 6 months only. And thereafter, the petitioner would not be able to get refund of the said amount. And further to that, as the validity of the said banker checks which were prepared had already expired, the petitioner sought the permission from the court for withdrawal, for initiating appropriate refund process. And as such, filed a petition bearing petition number 459/24. The learned trial court, by the order dated 2/2/2024, rejected the petition number 459/24 on the ground that the prayer of the plaintiff is not tenable at this stage, as the court had not yet finally adjudicated the matter. I specifically reviewed. It is against the said order, to the extent of rejection of the petition number 459/24, the instant proceedings have been initiated. This court, upon taking into account section 16C of the Specific Relief Act 1963, finds it relevant to take note of, finds it relevant to observe that the said provision requires the plaintiff to prove that he had performed or has already been ready and willing to perform the essential terms of the contract, which are to be performed by him, other than the terms the performance of which have been prevented or waived by the defendant. In the instant case, the plaintiff had duly purchased the e-stamp and paid the registration fee. The plaintiff claims to have purchased the e-stamp as well as the registration fee, purchased the instant as well as deposited the due amount for the registration fee. The petitioner the plaintiff further claims that he had purchased the demand drafts in respect to the remaining amounts. These aspects of the matter would be required to be duly taken note of while the suit is to be adjudicated. However, it cannot also be lost sight of that the e-stamp, so purchased, as well as the challan deposited for the registration fee of the amounts mentioned here in above, would become unusable. Unusable.
I can use, but subject to he registered the sale deed. The defendant registered the sale deed, but here the defendant refused to register the sale deed. That's why I filed the specific performance of contempt, the suit. And after period of 6 months, I cannot initiate the refund process.
No, but can you use this stamp?
I can use if she registered the sale deed.
So tomorrow, if it is given, then
Then I will purchase. I can purchase.
no. Can you use this stamp?
I can use this time.
So then,
My lord, if my money is unnecessarily blocked because she is not registering the sale deed.
this court cannot be unmindful of the fact that unusual would be just lying idle till the disposal of the suit. Similarly, the bankrupts referred to herein above have now become non-negotiable, taking into account that the period of 3 months have already lapsed from the date when the said bank drafts were prepared. While the said bank drafts have now become non-negotiable, the money would be unnecessarily lying with the bank. And no useful purpose, therefore, would be served. Considering the above, this court is of the opinion that the learned trial court is required to reconsider its decision in respect to the petition number 459/24, taking into account the above observations. The learned counsel for the petitioner submits that the next date is fixed on 28/3/2024. Accordingly, this court therefore disposes of the instant petition, thereby directing the learned court of the Civil Judge Senior Division Number 2, Kamrup Metro at Guwahati, to verify the details of the e-stamp, e-challans, as well as the bank drafts, which the petitioner oblique the plaintiff shall produce before the learned trial court on the next date in original, and thereupon keep due certified copies of the same. Certified copies can be made.
I have submitted a compared copy, already I have submitted.
No. The court can make it through the registry and keep copies and thereby keep due authenticated copies in the records, and thereupon decide as to whether any meaningful purpose would be served in keeping those bank drafts, e-stamps, as well as the e-challans, more so in view of the above observations. The bank draft, fresh bank draft, in respect to the remaining amount at the latest date. If so deemed. Yes, what is this?
It's a petition under Article 227, my lord, challenging the judgment and order passed by the, my lord, special tribunal under the Assam Land Grabbing Act. And since there is no any appellate authority, therefore, my lord, only remedy is by way of 227. Initially, we filed a writ petition under 226, and my lord was pleased not to entertain the petition in view of the decision of Supreme Court. And accordingly, by order dated 12/2/2024, the party was given to me to prefer this petition under 227. The Lordship may issue notice, my lord, because it is the first appellate. Under section 14, my lord, the government is supposed to constitute, my lord, special tribunal, appellate tribunal. And as on today, my lord, there is no any appellate tribunal.
Now, what has happened to your proceedings under the land grabbing?
Proceeding was, my lord, finally adjudicated and disposed of. Against, my lord, holding that I am not the owner of the land. There was
So
no
it went against you.
against.
If you notice. To the issue notice to the respondents by registered as well as usual, making it returnable on 1st of May 2024. The petitioner is directed to take steps within 3 days. The registry shall call for the records of special land grabbing case number 9 of the 2018 from the court of the additional session judge number 2, Nagaon, Assam. List accordingly.
My lord, in the meantime, my lord, the judgment may be, execution of the judgment may be stayed. Because there is a proceeding for, my lord, execution of the order by way of eviction.
Where?
As per the rule, my lord, there, as per the provision of the act, there is an execution
Let
provision.
it start. Let it start, Mr. Pukasta. Let it start.
In the meantime, if I am removed from possession, my lord, that will be difficult.
What? You
I
have,
I have been in possession.
then you don't have land grabbing case.
No, court says, my lord, I am not the owner. They are the.
No, it was
It is
your
business of
case.
the owner.
No, Mr. Pulkasta, it was your case
It is my case.
for land grabbing.
My-
You now have possession.
I'm in possession.
Then where is the land grabbing?
Hello.
What do you want? Should I dismiss it on that ground?
They said I am not the owner.
That's a different.
Tribunal has come to the conclusion that I am not the owner.
That's about it. Yes.
In this case, my lord, I am challenged the water effect, my lord, 9/11/2023, my lord. Whereby the my lord, petitioner plaintiff was denied to my lord, compare the my lord, photocopies with the original and mark them as my lord, exhibits. Lordship may kindly turn to page 59, the order, my lord.
Yes, what happened?
Before that, my lord, Lordship may kindly turn to page 41, my lord. It is not correct because my lord, the learned code below held that my lord, the plaintiff petitioner filed petition on 6/6, my lord, 17/5/2023. But it is incorrect, my lord. Lordship may kindly turn to page 41. Before that, my lord, the petitioner plaintiff was filed petition on my lord 11/4/2023.
This was filed on 11/4/2023.
3. Then
And-
the order passed on the same date, my lord. That is page 44, my lord. 11/4/23. Both sides are presented. I have seen the petition of so filed on behalf of the plaintiff, praying to allow them to compare the photocopies of the documents submitted along with the PW affidavits with the original and to mark them as exhibits. Considering the same, error is allowed.
So the marking was done when? The court must have marked it later on.
Till date, it is not marked, my lord. It was directed to mark, but my lord, subsequently, my lord, by the impugned order, it was my lord denied. So my lord, it has not been done till date.
Where is this court?
My lord, it is
One
my
more.
lord, the learned civil
Okay,
judge,
issue notice.
decision number 1, Dharam Mangal.
Issue notice making it returnable on. You can serve it. You're the plaintiff. You have an urgency in respect to the suit?
My lord,
Yes or no?
yes, I have that.
Issue notice making it returnable on 10/4/2023. The petitioner is directed to take steps upon the respondents numbers 1 to 5 by way of registered as well as usual. Further to that, the petitioner is also directed to take steps by trustee routed through the registry of this court and file an affidavit of service on or before the next day. I go to the petitioner within 3 days. The petitioner herein have assailed the order dated 9/11/2023, whereby the learned trial court modified the order dated 17/5/2023 and observed that the marking of the original documents as exhibits on 17/5/2023 cannot be considered with respect to the evidence tendered on behalf of the PW1. The learned counsel appearing on behalf of the petitioner has drawn the attention of this court to the petition filed by the petitioner oblique the plaintiff on 11/4/2023, bearing petition number 361/2023, wherein a prayer was made that the plaintiff may be permitted to compare the photocopies with the originals to mark exhibits. The learned counsel further drew the attention of this court to the order dated 11/4/2023, wherein the learned trial court had allowed the said petition number 361/2023, thereby permitting the petitioner oblique the plaintiff to compare the original with the photocopies, which was submitted along with the evidence on affidavit. It is therefore the submission of the learned counsel appearing on behalf of the petitioner that once the court have already permitted the said aspect and the originals were duly produced, the court could not have passed the order that impugned order dated 9/11/2023, thereby rejecting the originals, rejecting the originals of the documents which were rejecting the exhibited documents of the PW1, rejecting the documents exhibited by PW1. Taking into account the above, this court is of the opinion that the petitioner has been able to make out a prima facie case for stay of the further proceedings of title suit number. What is that suit number?
34 of 2017. Yes, 13.
34 of 2017, pending before the court of the civil judge Munsif number 1 Dorong at Mongoldoi. So accordingly, the said proceedings then stayed till the next day.
Item 9.
Yes, what is this?
The petitioner has present before your lordship order dated 12/9/2023. Excellent.
One?
Order dated 12/9/2023. Passed by the learned trial court, civil judge number 3, Kamrup Metro at Guwahati, by rejecting the petition for filing WS on the ground of expiry of 90 days. The petitioner at page 57. Annex 4.
Then what happened?
Yes. Now the proceeding is going on. Now petitioner defendant has been debarred from the contesting the suit.
Why you have come so late?
Because I was suffering from some illness.
Who?
Next, myself. I was the conducting advocate. I have annexed all medical documents.
You are the defendant.
Dependent, all main dependents, all main dependents. My father purchased the land.
Who are the plaintiff?
Plaintiff, there is three plaintiffs.
Who are they?
They are the Kusam Rongpi.
I also know Mr. Bora seeing from there. Who are they?
I am
Plaintiff.
plaintiff, the relative, my uncle's son.
You know their house?
Yes, I know.
Issue notice making it returnable on 5/4/2024. The petitioner is directed to take steps by way of registered as well as usual by tomorrow. So the petitioner is further directed to take steps upon the plaintiff, upon the respondents by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The instant petition has been filed by the petitioner challenging the order dated 9/12/2023, whereby the petitioners who were the principal defendants have been debarred from filing their written statement on the ground that the summons were duly served upon them on 13/6/2023. It has been mentioned by the learned counsel for the petitioner that there was no mistake on the part of the counsel, on the part of the plaintiff, the defendant, principal defendants, that is the petitioner, for which the written statement could not be filed, but it was on account of his ailment as the conducting counsel that the defendants could not file their written statement. He, however, submits that the written statement otherwise is ready and can be only filed if the order dated 12/9/2023 is interfered with. Taking into account the above, this court is of the opinion that the petitioner has been able to make out a prima facie case for further stay of title suit number 318/2023. Accordingly, title suit number 318/2023 pending before the court of the civil judge, senior division number 3, Kamrup Metro at Guwahati, stands stayed till the next date. What is this IA business?
Hello?
IA?
I is for stay.
What stay?
Stay for further proceeding. Sometimes it is required. So, separate application.
There is no interim prayer in the main petition, na? ये तो दूसरा order. What are you looking? You get your written statement ready.
Yes, it is still ready.
Serve it. If the matter comes up before me, the next day, we allow it subject to a cost minimum.
It is my ground.
Minimum. Because of that minimum, otherwise maximum. If it was Mr. Allama, it would have been more. Yes. Yes, what are you challenging, madam?
Lordship, I have a third party lordship to the execution proceeding. I have filed one petition. My third party petition was accepted. Page 52 is the first rejection order.
Why are you asking for stay?
Lordship, as Lordship, my third party petition was registered and it was taken into consideration, Lordship. Next date was fixed for evidence.
Your petition under order 21 rule 97 is pending.
Yes.
Huh?
Yes, Lordship. But no stay was granted. Lordship.
Then how can the court proceed with the execution
No, Lordship.
when there is a petition under order 21 rule 97 pending?
Lordship, kindly go to page 52, Lordship.
Yes.
Now, under Order 21, Rule 29, CPC provides for stay of execution pending the suit between the degree holder and judgment debtor. It lays down as under. Thereafter, first of all, let me mention herein that Rule 29 is an enabling provision and is not a mandatory or imperative in nature as it uses the term may. Thus, the provision of Rule 29 is discretionary. So now the question arises as to when the stay may be granted. It is well settled principle that this.
No, madam. Have you filed order 21 rule 97 petition?
Yes, Lordship, this is my petition, page 39. A petition under order 21, rule 29 and 97, 101, read with 151.
So if that is pending, how can they proceed with the execution?
Only because that, Lordship, I am under 227. Otherwise, Lordship, if I challenge the entire order, Lordship, it would be a amount to dictate.
Why?
I have not challenged that part, Lordship. That part, they have accepted my third party petition, Lordship. But no stay.
No,
was granted,
therefore,
Lordship.
when a petition under order 21 rule 97 is
Is
pending, isn't it required for the first to go decide that?
Lordship, that is for.
What does the
Lordship
Supreme
will
Court
find
say?
Page 57, the instant media case will proceed to adjudicate the claim of the petitioner under Order 21, Rule 97 and 101 CPC, 16/3/2024 for written objection.
Page
Page 57,
50?
7.
So therefore, the court is proceeding on the basis of that.
Lord.
Then why are you asking for stay?
Lordship, stay, Lordship.
Is
my
he
stay-
simultaneously proceeding with the execution?
Yes, Lord.
Where is that order?
Page 56. Before that, your Lordship will find as such the prayer for of stay of the execution case so and so under Order 21, Rule 29 CPC stands rejected. And then he held that, Lordship, my miss case will proceed for written objection. And then, Lordship, we have filed one petition under 151, specifically praying that as my third party petition was pending, Lordship, that execution.
Have you challenged this order
No,
of that order under order 21 rule 99? You have challenged that, no?
Lordship. Then,
Okay,
Lordship,
issue notice making it returnable on 22/4/2024. Steps be taken upon the respondent numbers 1, 2, and 3 by way of registered as well as usual. Further to that, the petitioner is directed to take steps by way of trustee routed to the registry of this court and file an affidavit of service on or before the next date. The petitioner herein have challenged the orders dated 1/3/2024 as well as 13/3/2024.
No, Lordship, 1/3/2024 interim stay was granted.
Oh, no. 2/3/2024.
Yes, and Lordship, last order 13/3/2000.
2/3/2024 and 13/3/2024. Being aggrieved by the continuation of the execution proceeding whilst WHIS, but the proceedings under order 21 rule 97 and 101 is taken up for disposal, is still pending before the learned executing court. It is the specific submission of the learned counsel appearing on behalf of the petitioner that the executing court has to first decide the proceedings under Order 21, Rule 97 and 101 before further proceeding with the execution of the said judgment and decree. So, taking into account the above and finding it prima facie and taking into account the above submission, this court is of the opinion that the further proceedings that opinion that title execution case number 1/2023 is required to be stayed till the next date. 1/2023 pending before the Court of the Civil Judge Junior Division Bizni is required to be stayed till the next date. This court, however, makes it clear that this court is not staying the proceedings under Order 21, Rule 97, registered as Miss Case number 6. No.
Yes, Lordship.
No,
64.
not 6.
Check is 6 of the 24.
No. It's case 6 came later on. What is the number? Miss J, case number 6/2024. That is the proceedings under Order 21, Rule 97 and 101. However, the learned trial executing court shall not proceed by execution of the decree in title execution case number 1/2023 till the next day.
Deeply observed.
Yes, Mr. Solia. What are you challenging?
Challenging the order of injunction, the rejection of the order of injunction will by the trial court.
Where is the order?
My lord. Nine. In FAO 75, it is at page 9.
This is what suit is for?
This is for declaration of title and because my land, although I had title over it prior to the defendant's purchase, same plot they said that we purchased and they got mutated. Same plot of land. Because I had also mutation after my sale, after my purchase. Ignoring that fact, Milord, they got it mutated and taking advantage of that, Milord, they encroached upon my land and have started building. But it's true that I came a bit late because I went to police, then to municipality. For that reason, Milord, they took advantage of that and they have built up the area completely. Just to keep it, that since they have already started construction, I came late. That's why injunction is rejected.
Where is the plaintiff? Who is the plaintiff?
I'm the plaintiff.
You are the plaintiff.
Mine.
Where is your plaintiff?
Mine.
No plaint.
Plaint is not here, my lord. The
Mr.
application for,
Solia, you have enclosed everything except the plaint. How
no,
can this be decided?
in the other case, my lord, the plaint is there, my lord. Voter
What other case? Aye.
case, my lord. Next month,
Arata Seni.
11 and 12. Item 12. At page 29 in this case.
Royal Ali.
Royal.
So you purchased 1 bigha. Your father purchased 1 bigha of land
My lord.
of Dag number 230 of KP Patra number
230,
4
yes.
and Dag number 229 of KP Patra number 9. Moda Jolukbari. Then your name was there, recorded in the list.
My
Yeah.
lord. My lord.
Huh?
My lord.
Where? In the Jamabundi?
63 million. Page 63.
Why you have enclosed page 654? Royal Ali. Defendant has filed written statement from counterclaim. And when did the defendant purchase? 91.
Yes, my lord. Long time. After a long time.
What is the counterclaim file?
Contract claim is my lord.
They challenge the sale deed.
My lord.
and the court have passed that order. Why there are two appeals?
One is, they also paid for injunction, my lord,
Ah,
defendant.
Hmm.
And their injunction prayer is allowed, and mine is rejected.
their injunction was for what? Therefore, under the, I am considering that the grant of injunction will place the opponent in more inconvenient state in a comparison. Moreover, the petitioner feels substantiated as to how he will face the event in view of the commission is effective. Your injunction is Ms. case number 928.
My lord,
Where is your Miss case? Injunction application? Yeah. Where is your injunction application?
at page 16, it is,
Huh?
yes, page 16,
60.
16, 16.
Ah.
In 7,
From entering the suit land. He is in possession. He is in possession.
that's true, my lord.
So obviously entering into suit land, you can't get it. Changing the nature and feature and character of the and also from construction. That
Yes.
you may.
That I paid for construction, copies of construction and all.
And what application he filed? His injunction application. Very difficult. There is no chronology to your applications being filed properly. It's not you keep it like this.
In case number 75, my lord,
There is no chronology, no?
their petition is at 18.
Yes, yes. Where is that application
At 8, at
filed by
page
the respondent? Injunction application.
Page 18.
Page 18.
1 8. Yes, 1 8. In case 75.
Yes. Now, what is the orders passed? 9 to 8 is your application.
My lord. 9 to 8 is mine application.
That application was rejected.
That 29 is DRT.
Rejected is because he is in possession of the suit land and he has raised construction of the suit land by spending rupees in crores and the said construction is at the verge of completion. That being so, in the light of the judgment of relied upon by the learned OP, I am of the consider that the prayer to me. Okay. Now let us see his petition. Defective.
His petition is in 75, it is at page 18. His case 29.
Yes, Mr. Alam.
Happy, Your Lordship.
Yes.
Lordship,
Why are you challenging his sale deed?
but my lord, by virtue of the sale deed, my lord, he has been claiming my land. My lord. By virtue of the sale deed,
Understood.
he has been claiming
He claiming upon your land is another thing.
my lord.
But why are you challenging his sale deed? There has to be a basis. There has to be a basis
Because-
that the sale deed has been fraudulently executed. The sale deed is
Apparently,
wrong.
my
The person who executed the document did not have the title over the land. There might be many aspects. What is your ground?
My lord, Your Lordship,
Or is it only on the ground that his sale deed falls upon your land?
my lord, the sale deed, he has produced a certified copy of sale deed, my lord, which shows a sale deed number 7070A.
Hmm.
My lord, the registration, they don't used to maintain seriality as A, B, C, D. So this creates false smoke,
That
false
is
smoke,
for the
my lord.
trial court to decide
My
at
lord,
the trial.
My lord, that
But
is-
how
that-
can the court allow you to construct? And how, tell me, okay, very well understood. You
that-
can
on this
construct,
ground, my lord, on
but
this ground,
how do you tomorrow,
my lord.
if it is found that his land is there, you are going to create third-party rights?
That has been protected, my lord.
Whatever you have done, that is your lookout. That is whoever has done it.
My lord.
But the question is the third-party rights having been created, further third-party rights will be created. How do you take care of that to put it reverse if the injunction is granted?
Your
Not
lordship,
the injunction in this manner has been given.
your lordship, you cannot see the imping order, my lord. Imping order, your lordship.
Yes.
Yes, page 8, my lord.
Hmm.
Internal page 8.
In which case?
In 75, my lord. 75. 75, my lord.
Yes.
Page number 16, my lord.
Yes.
In the light of aforesaid discussion under the context of the present case, it is found that in the present case, there is a case irrespective of the question of legality or illegality, which is to be decided in trial. The fact remains that the present petitioner counterclaimant is in possession of the suit land, and he has raised the construction of the suit land by spending rupees in crores. And the said construction is at the verge of completion. That being so, in the light of the judgment so relied upon by the petitioner, I am of the considered opinion that if the prayer so made by the petitioner is rejected, then it would have serious consequences upon the construction which is going to be going on since the year 2021 and is at the verge of completion. That being positioned, the construction which came up for inactiveness of the OP plaintiff cannot be directed to be stopped, and the fate of the construction is subject to outcome of the suit, my lord. It therefore, under the facts and circumstances, I am of the considered opinion that rejection of the injunction of this case will place the petitioner in a more inconvenient state in comparison to the OP. Moreover, the petitioner.
Okay, you give an undertaking
My
that
lord,
you are going to demolish the structure.
my lord,
Can you give an undertaking? No, Mr.
lord,
Alam, no, Mr.
my
Alam,
lord,
no.
the direction is.
I am not on that. Can you give an undertaking before the court that if he wins the case, you are going to demolish the structure without any further decree?
My lord,
Can you do that?
that direction is there, my lord.
No, forget about that. Can you give an undertaking? No, because you have already involved third parties.
Third party rights, my lord.
So, how could this court reverse everything? It
No,
is
but-
impossible to reverse. He had all the three ingredients.
My lord, in
We
case of
stay
my lord,
this.
his
We
case is
stay and no further construction. Enough.
construction has been
It's too
completed, my
much.
lord. Construction has been completed, my lord.
Huh?
Construction has been completed.
Very well. Don't do anything in the structure.
My lord, his prayer for recovery of position, man. He will get it.
As well as for
He-
demolishing.
By demolition, my lord, he has not shown any construction. So, if he gets the degree of recovery of position, he shall get the vacant land, my lord.
Sorry.
Get the vacant land, my lord.
No. How can you give a vacant land?
By court will demolish my land.
No.
I'll-
No. How are you going to?
Third
Now, many third parties will come in.
parties, my lord, have not come up today. Prior to institution of this lordship. Lordship cannot see in the plate. They have seen that I have raised construction in the year 2021. my lord.
My goodness. How
This-
does the court pass this order? See the language out here. In the light of the aforesaid decision under the context of the present, it is found that in the present case, irrespective of the question of legality or illegality, which is to be decided in trial, fact remains that at the present OP is in possession of the suit land and he has raised construction of the suit land by spending crores in rupees, and the said construction is at the verge of completion. That being so, in the light of the judgment so relied by the OP, I am of the considered opinion that if the prayer so made by the petitioner is allowed, then it will have serious consequences upon the construction which is going on since the year 2021 and is in the verge of completion. That being the position, the construction which came up for inactiveness of the petitioner over the suit land cannot be directed to be stopped, and the fate of the construction is subject to the outcome of the suit. Moreover, in the event of the success of the suit, OP may be directed to deliver the vacant possession of the suit land to the OP, whereas converse would place the OP in an unblemished condition of loss and hardship. Yes.
At last, my lord, last operative part, your lordship may cannot see. Under the present section, last paragraph, your lordship. I am of the considered opinion, the interest of justice will subside if the present petitioner is allowed to carry out the construction of the building, and the same is made subject to the ultimate decision of the suit. Further, if the third party interest is created.
Can it be done? No, because you are making a multi-storied building. And with that multi-storied building, you are creating third-party rights. Third-party rights, it would be next to impossible for him to execute.
My lord, before creating third-party rights, my lord, if condition has been imposed in respect of creation of third-party rights, I shall have to mention that litigation is going on.
Stay it immediately. And we also grant an injunction, no further construction.
Construction has already been completed by.
Don't create any third-party rights not to break, and I'm asking the police,
For
where is the building? Huh?
Near the pitch.
Adabari, my lord.
Adabari. We asked the officer in charge of the Adabari police station to give a report to this court what is the state of construction, and also the GMDA what is the state of construction, and then report back.
My counterclaim is speaking enough, my lord.
Have you got the completion certificate?
No, my lord.
Oh, better go.
Due to litigation, this litigation I could not apply. Due to pendency of this litigation, I could not apply.
Both the appeals are taken up together, taking into account both the appeals arises out of the same suit. All the parties are represented.
My lord, in appeal number 76, I have not got received the copy. I have not appeared.
Okay. We admit the appeal only.
76, my lord.
Both the heard Mr. D.P. Solia, the learned counsel, appearing on behalf of the appellants in both the appeals, and Mr. N. Alam appearing on behalf of the respondents. Both the appeals stands admitted and to be listed for hearing on May 9th of May 2024. Also, the calling for the records are not necessary for the purpose of the necessary in view of the materials are already before this court.
Records will be necessary, my lord, because relied upon documents of both the parties are not on record.
Huh?
Relied upon documents of both the parties are not on record.
However, liberty is given to the respondent to bring on record any other document which however, liberty is given to both the parties to file, to bring on record such documents as the said parties wish to bring on record the same. Wait, your main thing has not happened. But Mr. Solia, you tell your juniors, he doesn't know how to tell how to index a document. Is this the manner you do it? Finding the plaint, one has to then search where is the plaint. All because of you. This has
29.
happened.
Page
Where's the plane?
29,
Page
29
of
in 76.
76.
Right.
This is an application. I Oh, notice have already been issued.
My lord, yes, one case notice has been
This is an application under Mr. Solia. How can I help you? You're asking for a stay of an order. Are you not required to ask for an injunction? All because of you. I can't help it. If I stay it also, how does it matter? Tell me if I stay.
Yeah,
First,
yeah.
your application has been rejected.
injunction goes, my lord.
No, wait. Your application has been rejected.
My lord. DRT is allowed.
His application has been allowed to that extent that you cannot disturb. Nothing more than that. Nothing more than that. Then, are you not required to ask for an injunction for the court? Saying that, look here, kindly injunct them from further constructing or doing anything. Mr. D.P. Solia, the learned counsel appearing on behalf of the appellant, submits that he requires 2
I
weeks'
filed an
time,
IA also, sir, there.
2 weeks' time for filing an appropriate application seeking injunction in the matter. Mr. N. Alam submits that he does not have a copy of the FAO number 76 of the 2023. Taking into account the above, list the matter again on 5th of April 2024.
Maybe not on. Maybe 70 or 80.
Mr. Solia, are you at
I'll
all
be away.
concerned with your client?
I'll be away, my lord.
Ask him to appear or ask somebody else. Are you a senior counsel? If you are senior counsel, then obviously, how do you have any? Yeah, this is not at all the list the matter. You want it after Bihu? List the matter after 3 weeks.
Much.
The lordship will find your affidavit at page 76.
I beg to state as mentioned in the order dated demand passed and submitted on the Now you are in possession of the property. Now, how do you effectuate to the recovery officer?
My lord, it was under attachment way back in 2811, 1011, my lord. Now it was under attachment and the auction sale order was passed. Now therefore, my lord, so far the recovery proceeding is concerned, there is no appeal filed by them. The certificate is still in existence. So therefore, the order was passed and they filed an application here to stay the order dated 1/12 passed by the recovery officer, which your lord will find at page 70, my lord, 70.
Then
And this order has been stayed by this honorable court, which your lord will find at page 28
till
of the
till the return the impugned order dated one passed by recovery officer Guwahati in RC case arising out of so and so shall remain state.
Well,
Where is that order?
that is at page 29. 29 of our application to vacate.
2023. Where is that 1/2
Huh?
2020?
27 to 27 to 2023.
So this has been stayed.
This, my lord, the order passed by 1/2/2023 that has been
Has been
stayed
stayed.
by this honorable.
1/2/2023 relates to auction.
Released to
Order
auction.
that the mortgage property described below will be put to auction sale by auction through the e-auction portal so and so basis and email. So now in view of your affidavit that you are not going to go ahead with the surface procedure. The further continuation of the proceedings shall be under 1/2/2015.
Beg your pardon.
The further continuation, therefore, in respect to those three properties
Yes.
will be as per 1/2/2015.
Exactly.
So the possession has now been taken.
Yes.
By you.
Possession is with us.
Now, did the recovery officer earlier took over the possession?
Yes.
Recovery officer had also taken over the possession,
Right.
and because otherwise he could not have gone for auction sale.
Exactly.
So now you are in possession this way or that way, but earlier it was legally with the recovery officer.
Right.
Possession was with the recovery
Yes.
officer as per the DRT Act. But now it is the possession, it is now we are having the possession of two
Right.
in view of the two acts coming into play.
Right.
One is as per law with the recovery officer and the other as per law as per with you.
Exactly.
Now there is a direction being passed wherein an appeal for you to hand over. Now, if you withdraw the appeal in the DRT, the effect would be it would amount to handing over to them.
It will be with us.
How?
The moment we withdraw, because the physical position your lordship may kindly see at page, my lord, 68. 68, my lord, of the revision petition.
68. Yes.
My lord, the CHB file report that, as your lordship granted, 3 mortgage properties have been identified out of 5 properties. An order of
Page
attachment.
68.
68, my lord, Annexure 8.
Pradeep Kumar, nodal officer appeared
Right,
as certificate.
right,
Yes.
Now, the next your lordship will find CHB file report that 3 mortgage properties have been identified out of 5 properties. An order of attachment has affixed on conspicuous as part of the mortgage properties and also file affidavit in this regard for identification of property. CHB further stated that the 3 properties mentioned in Schedule 1, 2, and 4 are under possession of CHB
under SARFAESI Act 2002. And these properties have also been attached by this learned tribunal by order dated 10/11/2022. Hence, now CHP has decided to withdraw, even in that proceeding also, my lord. We paid for that, but the learned court did not accept that. They said you contest it. Now CHP paid for further action in the matter under RDB Act. As huge amount is to be paid by CHD. It is observed from the submission of THB that properties mentioned in so and so under physical possession of THB. And now these properties have been attached by this tribunal on 10/11/2022 under RDB Act 1993 for realization of recovery certificate issued by the honorable presiding officer. Hence, it is directed to CHP not to hand over the possession to CHD.
So this order was passed pursuant to the DRT's order under 17.
The 17 order was passed later on. 4/1.
4/1/2023.
2023.
Okay. Now, why does the question come in the last line? Hence, it is directed to the CHP not to hand over the possession of the CD till further order as properties have been attached by this tribunal. Where is the question of handing it over to the CD?
That line was not necessary to be added. In a physical position, I am told it was taken earlier.
My lord, that's why just I want to correct it, subject to lawsuit. The physical position was taken by virtual SARFAESI on 38/2022. 38/2022.
Initial possession.
Yes. Under 13(4), physical position they have taken over. 38/2022.
22. Under 13(4).
Yes.
Okay.
So prior to that, they have taken the physical position. But when you have taken the physical
But
position,
that possession is of the bank.
yes, with them,
With the
all
bank.
throughout. Now today also throughout it is with the bank. Throughout.
It's okay.
Even there is a, your lordship has put a query, even there was a direction passed by this by DRT in respect of all these proceedings for SARFAESI, saying that you hand over the position back to them on 2nd of February.
Now, interestingly,
Yes.
on 10/11/2022,
Yes.
the recovery officer attaches it.
Correct.
Yes.
Once it is being attached, the property then, by virtue of the provision of attachment, is with the custody, maybe in physical custody with them, but is in the custody of the recovery officer. Couldn't that be?
Yes.
Because this is under attachment.
Yes.
So maybe physically it may be them, but legally it is under the recovery officer.
Recovery of.
So under such circumstances, whether they go ahead with the recovery procedure, SARFAESI or not,
But what I just, because I don't know, I thought whether that attachment already it is with the bank. Already physical possession, total possession, because it is not my possession, it is with them. Now, whether recovery officer should have gone for attachment. Already physical possession was there, one. Secondly, knowing fully that particular this SARFAESI order has been put to challenge before the DRT and it has been stayed. It has been stayed.
no, that happened later on.
So, yes, correct.
You see, DRT happened pursuant to 4/1/2023.
Yes, right.
But the attachment made by the recovery officer happened
pursuant
on
to that.
10/11/2022.
Prior to that, right.
Yes. If it was there on 10/11/2022 with that attachment, the possession legally vests upon the recovery officer.
Yes.
Correct. Let us
Maybe it may be with them.
No, right.
It's a different
Right.
thing.
No, now legally it is, let us say that legally it is with the hands of the recovery officer. Number two will come. If it was legally with him, whether this is a point, whether he could have gone for an auction sale in view when the proceeding was pending before DRT, which goes together at one point of time.
But DRT proceedings is against that the SARFAESI.
I'm sorry.
DRT proceeding is against SARFAESI.
Right, correct.
That is
But
immaterial because the SARFAESI proceedings clearly does not, is in addition, not in a derogation.
Right. But the option of the bank was to go ahead either to choose whether to go ahead with the SARFAESI, because your lordship will see one order during the pendency of the recovery officer. What I just trouble your lordship with one.
Recovery of debt action or SARFAESI.
Kindly see at page 68, my lord, for a moment.
That is 68 I'm looking.
68, and kindly see third paragraph.
Hmm.
Third paragraph, CHP further stated three property mentioned in so and so, and this property have also been attached by this tribunal by order dated 10/11/2022. Hence, now CHP has decided to withdraw recovery proceeding
Hmm.
under provision of SARFAESI and to proceed further with so and so. But this order was passed on 28/11.
But they did not recover,
They
they
did
did not withdraw.
No, they did not withdraw, and they went ahead before the DRT.
The last amendment is of 2021, this Recovery of Debts and Bankruptcy Act,
Yes, 2020,
21.
21.
Now kindly come to section 34 of this Recovery of Banks, Debt and Bankruptcy Act,
Section 23.
34.
34.
You see, save as otherwise, save as provided under subsection 2, the provisions of this act shall have effect notwithstanding anything contained therewith, anything inconsistent therewith contained in any other law for the time being in force or in any instrument having effect by virtue of AI. Now, this was not an amendment being brought in 2020. There's no amendment made there. But you may see 1, 2, 1. Now kindly see the provisions of this act or the rules made therein under shall be in addition to and not in derogation to so and so. So this provision of recovery of debts is in addition to these acts. But SARFAESI is not here.
If you see your lordship, just for a moment, kindly see the rule, the SARFAESI rule, 2002 section 8, rule 2(8), rule 8.
Wait. Let us see this derogation.
Yes.
Petition. The provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force or any instrument having by effect of law. So now, whether the SARFAESI Act wouldn't have overriding effect over the Recovery of Debt Act?
No, the overriding effect will not be there, but then both the acts, my lord, can go together simultaneously.
Understood. It can go. But the moment it is inconsistent, then, just for example, here you have taken action for taking over possession.
Yes.
This taking of possession happened on 30/8/2022. If that action has been taken, then could you have gone for attachment under 10/11/2020?
That was done earlier,
Which one?
this attachment.
No. Attachment happened on 10/11/2022.
10/11, yes. 10/11.
Whereas the physical possession under 13/4 was taken on 30/8/2022.
So if your lordship is rightly has been put, that's why I'm showing rule 8. What is rule 8 in respect of that, of the SARFAESI? Rule 8. Kindly see rule 8, my. Sale of immovable, rule 8. Sale of immovable secured assets. Where the secured asset is an immovable property, the authorized officer shall take or cause to be taken possession by delivering a possession notice prepared as nearly as possible so and so to the borrower, and by affixing the possession notice on the outer door as such conspicuous place of the property. See now, possession notice referred to in sub-rule 1 shall also be published as soon as possible, but in any case, not that in 7 days from the date of taking possession, 2 leading newspaper, 1 in vertical, so and so, so and so. All notices under this rule may be served upon the borrower through electronic mode of service in addition to the mode, so and so. In the event of possession of immovable property actually taken by the authorized officer, such property shall be kept in his own custody or in the custody of any person authorized or appointed by him, who shall take as much care of the property in the custody as the owner of the ordinary prudence would under the similar take of such property.
Okay, we'll hear it again that too.
Yes.
No, only thing is, think about it one thing, that the action resorted to you under section 13 is an action taken by the bank.
Yes.
Now, once the bank takes over this, it is at their volition this action is being taken. But by operation of law, more particularly, if you see section 13 or something,
13(2).
Now, 13(4) says
34.
13(4)
13(4).
that the borrower fails to hear, the secured creditor may take possession of to such or to one or more of the following measures to recover his secured debt. If that be so, can you withdraw that? If you can withdraw it, then what the attachment can be done.
I'm sorry.
If you can withdraw it,
No.
then attachment can be done.
That's right.
If you don't withdraw it, then there cannot be an attachment. So there may require, if you withdraw it now, wouldn't it require fresh attachment? Taking into account the overriding effect under section 35. We'll take it up at
34.
35.
35.
35 of that act of SARFAESI,
Yeah.
which says that it will have an overriding effect. So obviously, this act, although it was amended, the Recovery of Act was amended in 2001, 2021, but this act of SARFAESI was not brought in. So if it was not brought in, meaning thereby section 35 of the SARFAESI Act still holds. So if that be so, the provision, if they would want to withdraw, the attachment order has to go.
Then there
Because of the possession having the attachment, the property in view of Rule 8 is in the hands of the authorized officer. So once you withdraw that, then he can go and
but he has to again issue a press notice for attachment.
whatever
Once
may be, that is another thing.
That
But
we shall
the
look at.
attachment has to be only subsequent to the withdrawal.
Yes.
So it can't be that once we attach and then withdraw, because it will have a overriding. Let me just do.
We shall look in. 1/4/2021. The virtue of 34, which came later on 2002, the SARFAESI Act, that will have overriding effect any other law. It will have overriding of any other law, which in RNDP it's a 34 of the Act, that's overriding. That's a 1993. 1993. Now here, under the SARFAESI, my lord, under section 13(4), the physical position has been taken. 13(4). Now, the under 8.2 and 8.2, 8.1 and 9, 8.1 and 9, where the, under the rules, my lord, the possession takes over under the 13.4, and it has now the attachment, in place of attachment, physical possession will be there. So they can go ahead under 9 for sale.
Doctor?
Under section 9, they can go ahead for sale. Under, sorry, rule 9, they can go ahead for sale. But this was taken on 30/8/2022. The physical possession, the Virtual SARFAESI Act was taken on 30/8/2022.
No, Mr. Das, I understand that. You see that the interplay between the two acts is this. 34 of the Act of 1993 categorically mandates that it will have an overriding effect in respect to the laws which are in force. This provision was not amended by the 2021.
Yes, right.
Under such circumstances, if that provision was not amended, the law in force at that point of time was not the SARFAESI Act.
Right.
Whereas Section 35 of the Act of SARFAESI Act states that this act shall have overriding effect over all other laws, meaning thereby that the possession which have been taken by virtue of Section 13.4, read with Rule 8 of the SARFAESI rules, overrides the provisions of that 93 Act.
Right, 93 Act. Yes.
Now, if that be so, the attachment which was made pursuant to the exercise of the powers under 13.4 was wrong. Now, if they have to withdraw, the moment they withdraw the proceedings, the SARFAESI, they have the option now, still now, they can withdraw the proceedings. The main, once they withdraw, then there has to be a passing of a fresh attachment order.
Correct.
And with that attachment order, they can carry away.
Yes.
But they have to withdraw the SARFAESI proceedings.
Right. Which they have, my lord, at one point of time, they have given undertaking before the recovery officer that we are going to withdraw it. They knew, my lord, they want to withdraw it, but they didn't withdraw it. Now today, because your doctrine of election will come into force on the 35, they can go simultaneously. But what happens when they meet the loggerhead, then what happens? So that is why they also knew. Before recovery officer, they made a categorical statement that we want to withdraw this certificate. But they have gone ahead and they have filed before, again, the order passed.
No, they knew on 10/11/2022 that their proceedings on the SARFAESI is going to the dustbin.
Yes.
So therefore, they made that statement. Then also they thought that let us try and play the game of chess. Isn't that me?
Yeah.
You never know what happens.
My lord, the question would be whether the attachment order will have to be asked once again. Now, my lord, your lordship kindly see at page 67, the attachment order itself.
Yes.
Whereas you, the above mentioned certificate debtors, have failed to pay the sum of rupees so and so, plus interest and cost so and so in terms of recovery certificate bearing number so and so, passed by the learned presiding officer at Recovery Tribunal Guwahati in case number 12. It is ordered that you, the above mentioned certificate debtors, are hereby prohibited and restrained until further orders of the undersigned from transferring or changing the undermentioned property in any way, and that all persons be, and that they are hereby prohibited from taking any benefit under such transfer or charge. Now,
So this is not
the,
actually an attachment order.
my lord, in whatever way, my lord, he has.
This is
passed
more
this
of an
order.
injunction order.
It's like that, my lord. But then it is with the recovery officer only. Now here there is no question of possession and all that.
No,
Now-
therefore, this is not an attachment order. Attachment have happens what? When you attach it, it is taken into possession of the court.
Position of the court, yes.
This is not the order.
It's not exactly that way, but in that regard.
This may remain.
Yes,
This can continue, but
This-
this can't be termed to be an attachment order.
my lord. Now, the next, my lord, your lordship kindly see section 37 of the SARFAESI Act.
Yeah.
Application of other laws not barred. The provision of this act or the rules made thereunder shall be in addition to and not in derogation of the so and so. The last your lordship will find the recovery of debts due to banks and financial institutions.
Therefore,
Act 1983.
this provision is not there in 34.
Yes.
That is what I've been telling you. Therefore, this act supersedes the act of this particular act of 93.
93.
You can go ahead
Yes.
under the 93, but the moment there is a conflict, this act, SARFAESI Act, takes the upper hand.
But now at this stage, my lord, so far SARFAESI action is concerned, we are going to, even in fact, my lord, before the debt recovery tribunal also, we filed an application, but the learned judge did not accept it. Now that my learned friend has said that we wanted to withdraw, but we did not. That fact is not correct. So the court did not allow, and we had to go on.
No, it's okay. But you have to withdraw.
Yes.
I'm not saying the SARFAESI proceedings.
Yes.
The DRT proceedings. You may withdraw
SARFAESI action.
the SARFAESI actions, which in turn may allow you that not to proceed with the appeal.
Rightly. Ultimately, my lord, also,
You may the withdrawal of the DRT proceedings is different from
different.
withdrawal of the SARFAESI.
But the moment SARFAESI action is withdrawn, automatically, my lord, appeal will go.
That is a different thing. That is also another course of action which you need to take.
Yes,
Your appeal will therefore fall up.
yes.
With the withdrawal of the SARFAESI, nothing remains. The appeal becomes infructuous.
Exactly.
But a question, however, may remain of the proceedings of section 17.
Right.
As to whether anything has happened, any loss which has happened, what is required to be done.
Right.
So as of now, you have to withdraw the SARFAESI proceedings.
Yeah.
If you withdraw the SARFAESI proceedings, then only the further action. But this is not an attachment order. They may put it as an order of attachment of immovable property. Order of attachment is, if I know, is an attachment by which the court takes over the possession.
Takes over the position, and it is the property of the court.
Thereupon, whatever will happen,
But your lordship has seen the language, it is more or less like
in injunction, not to transfer of
Exactly.
property.
Now, the next, my lord, I'd like to take your lordship to section 25 of the Debt Recovery and Tribunal Act. The mode of recovery, my lord, how it is. The recovery officer shall, on receipt of the copy of the certificate, the subsection 7 of section 19, proceed to recover the amount of debt specified in the certificate by one or more of the following modes, namely, attachment and sale of the movable or immovable property of the defendant. This is one of the modes. Second, my lord, AA, taking possession of property over which security interest is created. For any other property, we are not on that, my lord. First mode is attachment and sale of movable or immovable property of the defendant. So therefore,
Because
my
you
lord,
can neither attach or sale by the recovery officer till because of the property has now been taken over by you in view of 13(4).
So therefore, my lord, the moment we do the SARFAESI action taken by us, then that field is all over. Now we fall back to section 25. Now 25, my lord, attachment order is
So
already
don't you
there.
think that you need to first do that?
Beg your pardon?
Don't you think now
Yes.
that you need to first withdraw the SARFAESI proceeding, the horse, what is appeal is pending or not?
That is, my lord, we are just contemplating.
If you do that, then this court may further pass appropriate orders. What do you say?
Exactly.
Would that be not the proper course of action? for you. You withdraw the surface. Then legally, the jurisdiction is there. It's a different thing. You have suffered a judgment. The consequences of the judgment is different.
Yes.
May not, whether your appeal will be maintainable or not, that is another aspect of it.
Right.
But you first need to withdraw the surface proceedings. Once the surface proceedings is withdrawn, then 25 immediately can kick in.
Yes. That is what I want to persuade you, Lord.
I am persuaded. But first, don't you think that 25 you need to withdraw?
That is.
Otherwise, this court has to pass an order that you have to withdraw. Then only this will happen.
My Lord, pursuant to your lordship's, my Lord, instruction on other day, we have filed an affidavit and very
I've seen it.
categorically, we have stated that.
Yes, you have said that, but you have not withdrawn.
No, my Lord, because it is coming up on.
That's a different thing. It's coming up. That is, therefore, I'm saying
Yeah.
the appeal is on account of suffering a judgment.
Yeah.
Whether that appeal remains maintainable thereafter, in view of the withdrawal of the surface proceedings, it's another aspect of the matter, which that DRAT will consider.
Right.
That is another aspect. But for the purpose of getting the jurisdiction to the recovery officer, you need to withdraw.
Yes. That I am confident.
But you have only said that you are going to withdraw.
Right.
The learned, yeah, what you are saying? Okay, paragraph number 4.
Paragraph 7.
4, na?
Just
4.
Paragraph, my Lord, yes, 4.
Paragraph.
Paragraph 4, page 76, my Lord.
So unless you recover, you are ready and willing, but you have not done that.
Some rider is imposed, my Lord, your lordship has seen that in view of section 19. There is a, my Lord, 19 of the SARFAESI Act. There is a compensation, my Lord, related to that.
No, the
No.
compensation would not fall.
That
That
tribunal
the tribunal will decide.
Tribunal will decide.
Or the tribunal may not decide. The court will decide. The DRT has to decide.
Yes.
DRT has not decided that.
That hasn't.
So it will be thinking in the stars that one day it will do so.
My Lord, the statement has been made and we have.
No. Otherwise, the problem is this court has to uphold, set aside the judgment order. Now, this court has to set aside this order. Whatever may be, the further proceedings.
First, there must be action on our part. I understand that.
Then you don't give the jurisdiction. Once that happens,
Yeah.
I think the only thing is this court then has to, then this court can very well direct the recovery officer to proceed because there is no problem with the as per law.
Well, just 1 minute. My Lord, let you lordship do one thing. Fix the matter after 20th March it is fixed, my Lord, in the appellate tribunal. So just after that, your lordship fix it.
Okay, well, let us have it on 1st of April.
First April, my Lord, or some other date. my Lord.
You don't want
Before
that. It may lead to pulling up somebody. Okay.
1st April, I'll not be here. My Lord.
Okay. Then third,
Before that,
you want after 28. Thereafter, the court is not sitting.
20th March, my Lord, next.
28.
20.
20. 22nd.
20, yes,
Today is 18th.
it's fixed on, I have been told.
Today is 18th.
20th March. Is 21st. 21st. Oh, 21st. 21st.
22nd.
Yes. Yes, no problem. No. 21st will be okay.
This court have duly taken note of. the affidavits which have been filed by the respondent as well as the counter affidavit filed by the petitioner. A question duly arises as to whether the whether the recovery officer as on date can exercise the powers under Section 25 of the Recovery of Debt and Bankruptcy Act 1993 till the respondent bank continues its actions, continues to take benefit of their actions under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. Mr. S. Dr., the learned senior counsel, appearing on behalf of the respondent bank, seeks for an accommodation to list the matter on 21st of March 2023. Interim order passed by legal.
Much of further hearing. Further hearing.
Okay. This month, I'm there. Mr. Chaudhary, I
Yes,
think you need to ask for a slight clarification from that judge.
Counsel, give me 10 minutes time.
Huh?
Give me 10 minutes time, I'll try to persuade you lot.
Because
I have followed.
otherwise the problem always will remain.
My lord, there are two
I keep this
aspects.
matter. You file an application just for that. I think that will solve all. And he will do it. Because he also will see that this is the mistake. Once that is done, then nothing remains in this. Everywhere I go, I get stranded with that interim automated.
I got a judgment, can I place that?
Yes, yes,
Yes.
please.
Before that, I'd just like to point out one thing, my lord. There were two writ petitions. First writ petition is WPC number 614 of 21, where we challenge the seizure, where this 10% order was passed, along with the order of no coercive. Subsequently, my lord, when they filed the affidavit in the first case, then we got to know about the offense report. Then we laid a challenge to the offense report in the second writ petition.
Where also no coercive measure.
There also. Therefore, my lord, there were two interim orders. Now, I was trying to rely upon that judgment, my lord. Actually, my lord, what had happened, there was an adversary. Just to look after the adversary during the, my lord, pendency of the writ petition, that order was. Eventually, my lord, that order marched with the final order. That's what the Supreme Court says in two orders. I'll just like to place that. Only
It
for
normally merges.
Yes.
There's no problem with that.
yes,
But you see, it is something like this. Sometimes interim orders are passed
yes,
or temporary injunction orders are passed.
yes,
These temporary injunction orders are made absolute.
Yes.
After that.
Yes.
Once it is made absolute, that temporary injunction order takes the flavor of a permanent injunction.
their marginal principle may not strictly stricto facto apply, my. Now, my lord, will kindly see two judgments, my lord,
Mm.
that Chamundi Moped Lordship knows that what is the stay order.
Yes,
what
yes.
the
92, 1, 2 SCC or 1 SCC page 1.
92, 3 SCC page 1.
Page.
But because আসেনি।
You're referring to paragraph 22.
10, my lord.
Okay. Yes, tell me. It's on the effect of stay.
Yes. This stay order of the High Court cannot have the effect of reviving the proceeding which has been disposed of by the appellate authority by its order rejection. While considering the effect of an interim order, staying the operation of the order under challenge, a distinction has to be made between quashing of an order and stay of operation of an order. Quashing of an order results in restoration of the position as it stood on the date of passing of the order which has been passed. So what we would respectfully therefore submit is, my lord, while though on the ground of technicality, when the entire offense report was interfered with, the position which was obtaining on the day when we approached this honorable court, that revived. That is, I was just trying to place for a lordship kind of whether that expression used in the order, that interim order is also made absolute, whether that will take away our right that kind of, because the main subject matter of challenge has been interfered. So it no longer exists. Whether, my lord, in that view of the matter. And the other case, my lord, other case is that BPL's case, state of West Bengal.
Do you have a copy of your earlier writ petitions?
Yes. State of West Bengal. My lord, the other writ, here we have annexed. Or can this writ petition be along with the other two writ petitions? So disposed of.
I will do, but the fact is, why I'm not calling it is the moment I call it, for you to file that IA becomes a big problem.
Okay, my lord, we file a review.
Not a review, just clarification. Only that. Once that is being done,
Yes. Instead of, I know, my lord, it's slightly gray.
no, another aspect which this court can do, but this will be a very long, lengthy process.
Yes.
And this will also lead to various proceedings. Because they are going, as you say, they have a malice in law or malice in fact.
So they will take advantage.
So they will take an advantage, and this matter would only get you at the end of the day, you are not going to get a relief for years, which may not be in your client's interest.
And then we'll get a clarification.
I think that I'll have it after a month.
Yes, after maybe before Bihu, my lord.
Before Bihu is.
We'll try our best to do it in the meantime. In the week before holiday.
You don't have time, na? Because you see, we are in this week. Next week only 2 days. Then the 1 week is there.
So 27 and 28 only working.
Anyway, let's try our luck on 9th of April.
Yes.
Release this matter on 9th of April. Mr. K. Chaudhary, the learned senior counsel, submits that he would advise his client to file an appropriate application seeking clarification to the judgment and order dated 30/3/2023, passed in WPC number 614/2021 and WPC number 3745/2021, whereby the interim order was made absolute. List the matter on 9/4/2021 for 24 for further question. I put that out there so that it helps you there.
Yes. Diploma.
Production list.
Hygienic. Yes, what is this?
I need time to rectify the defects in this case.
Huh?
Some rectification is required in this case, so I'm paying for some time, to rectify the defect.
When did you file the appeal?
It was filed on 15/12/2023.
Hmm?
15/12/2023.
15/12/2023, and it has not yet been rectified.
I came to know on the last week, about the tendency.
There are many orders being passed. Who is Mr. M. K. Shah?
My
Huh?
myself.
Then, so many times you have been asked to make the correction. Why you have not done that?
I have taken twice the opportunity, but due to my health issue, it will not.
You have filed this appeal without the original or certified copy of the judgment. You have filed the appeal without court fee. You have filed the appeal without the certificate which is required. You have filed the appeal without the signature of the advocate in the wakalatnama. You have filed the appeal without the age of the appellant required to write in the court title. You have filed the appeal with no synopsis, no index. How many years of practice do you have?
Since 2000.
Huh?
Since 2000. Since 2000.
So, we are today, how many years? 24 years? And you don't know that the wakalatnama requires the signature of the advocate?
Your Lordship, it is given to the filing advocate's clerk. It is somewhere in this documents were given to submit in this case. It is missed.
Then you were asked to make the correction. Have you done that? On 27/2/2024.
Yes.
Did you make the correction?
I appeared, for correction, but due to my health issue, I could not done it.
Huh?
Due to my health issue, I could not done it.
Then again you have appeared on 7/3/2024. Have you done that? When you are correcting it?
Yes, Lordship.
When are you correcting it?
By this video.
This week. Hello, we have it on 22nd. What do you require to correct?
Everything, whatever asked for, I will do the necessary correction.
You have done some, because of that, you have placed it before the RERA authority that there is, you have filed an appeal and the RERA authority have stayed it.
No, no.
Then the RERA authority is not proceeding with the appeal.
It is not heard yet, until and unless heard yet, no stays.
Huh?
Matter is yet to be heard,
No. There is an order here, sir. Appellant has filed a case on 15, and after that, the appellant learned counsel had taken file for correction and returned back to the filing section of the Honorable Court on 6/2. After that, in public domain, objection on Iman. No original document has been so and so. Amen. After the application by the Iman for inquiry and Surya, then the file has returned back by the appellant counsel, but again plenty of defects, and what is done by him. And till now, the file is in defective counter till date, and he has not verified any and not corrected the petition. How can the whole petition can be defective, and for a long time the file is here with an intention, Iman, and hold the inquiry of the aforesaid matter registered against the appellant Dinesh Sharma before the RERA. So please inquiry. Hello. You are challenging what?
Impugned order.
Where is the impugned order?
Required to be correct the file, right?
There is no impugned order enclosed.
Yeah, that is the order dated 18/5/2020, 16/10/2023.
Why you have not enclosed the impugned order?
Such a defect is required to be cured,
We dismiss it.
Given some time.
No, sorry. I'll dismiss. This cannot be done.
Due to hurriedly by the advocate clerk, it is missed, Your Honor.
We will dismiss it with a direction to the bar council to initiate an inquiry against you.
I will be given a liberty to file a press, Your Honor.
Absolutely no. I'm dismissing it because it does not contain any substantial question of law. You file this without this, knowing fully well. Look here, what I'm passing the order.
I have challenged the impugned order that is.
Why you have not enclosed the impugned order?
It is given to filing clerk, but it is missed, Your Lord. I
Whom?
will place by 22. This could
No,
kindly-
we are having it tomorrow. Again, I'm having it tomorrow.
I need to.
No, no, Mr. Counsel. You can't take advantage of that. This court is not, you may take advantage of other courts, not me. You don't make it all these things. There's nothing out.
Kindly,
You
the-
file an affidavit by tomorrow before this court. Why these defects have not been corrected? I'm taking up tomorrow at 2 p.m.
Okay.
List the matter at tomorrow at 2 p.m. The counsel appearing on behalf of the appellant shall file an affidavit giving details as to why the defects which were directed to be rectified by the registry have not been done so. Full stop. The registry shall also place before this court a report as to whether the defect was placed was the defects in the appeal was placed before to the council, and as to whether the council had taken back the said appeal and again resubmitted on 6/2/2024. List the matter at 2 p.m.
Okay.
File your affidavit.
Thank
এখন immediately লিখে দিব দেই তারপর রিপোর্ট And Mr. Counsel, be careful. Tomorrow, we may send you to bar council. Yes. You can hold. Yes, what is this?
Look, here, my lord, my application for amendment was rejected. I was the plaintiff, my lord. In the plain, the sale deed number which I put to challenge was wrongly been typed. And that was the only correction which I sought for by this application at page 46.
So this order I passed in 2021 and now it has come.
Now, after that, it was the notices were issued. And the,
Notice was, there's no notice business here. I
No.
passed an order on 23/11/2021.
so it was listed before the Lordima court, my lord. And
Asking you to submit, give a copy. You are appealing for the respondent.
I'm actually for the respondent 1 and 10, ma'am.
What happened to the others?
others notice has been served, my lord, but they have not appeared. Only respondent number
Which order is this? You are asking for setting aside the order of 23/6/2016.
my lord, page 55.
What is that? Thought for the following amendment. What is the stage?
At the evidence case.
Huh?
Evidence case. TW.
PW1.
No, my lord, the evidence was not filed. It was for filing the evidence. At that time,
However, on the part of the plaintiff as well as the annexer, it repeats.
possible, kindly find page 48. These are the amendments, my lord. page 48, was my application for amendment. Down below, my lord, will find amendment sought for, page 48.
In the fifth line of the paragraph, the lead number may be corrected. In This is the amendment you sought for.
This is there.
Yes, what do you have to say?
Probably only the salary number matter.
And 2016 it is pending. No. This is an application filed under Article 226, 227,
1 month.
115. This is an application filed under section 115 of the Code of Civil Procedure, challenging the order dated 23/9/2016, passed by the learned Munsif number 2 in Midday case number 185/2015, arising out of title suit number 511/2010. By the impugned order dated 23/9/2016, the application so filed, the application for amendment of the claim was rejected. This court, taking into account the amendment to the Code of Civil Procedure 1908 by the Amending Act of 2002, is of the opinion that the instant application is not maintainable under section 115 of the Code. Be that as it may, for the interest of justice, the instant application is converted to a proceedings under Article 227 of the Constitution. This court had duly taken note of the impugned order dated 23/9/2016, passed by the learned trial court, whereby the application filed by the petitioner, plaintiff, was rejected. A perusal of the impugned order categorically shows that the said order has been passed. Categorically shows that the learned trial court erroneously have dealt with the merits of the said application seeking amendment, the merits of the amendment sought for, and not what was required to be taken note of in terms with the provisions of Order 6, Rule 17 of the Code. This court have also taken note of the application filed under Order 6, Rule 17 of the Code, and from a perusal thereof, it reveals that the amendments so sought for are necessary for the purpose of effective adjudication of the suit. Further to that, the said amendments under no circumstances would change the nature and character of the suit property. Consequently, as the learned trial court did not consider the said aspect of the matter, the impugned order dated 23/9/2016 is set aside and quashed. The petitioner, the plaintiffs, are directed to file their amended claim on today's what date?
18 minutes.
Adi kudai?
18.
Adi 18. 18. Is directed to file their amended claim by 2nd of April 2024 before the learned trial court. Full stop. The stay order dated 22/12/2016 passed by this court, since vacated in view of the above directions.
All right.
All the parties who are duly represented. The parties herein are directed to appear before the trial court on the date above mentioned.
May please your lordship.
Which is staining. Not the orders one. Yes, what is this?
Lordship,
Transfer?
Yes, sir, Lordship.
Transfer from where to where?
From Guwahati to Sagar,
What are you asking for transfer? MSc case?
MSc case, your lordship.
Why?
Because inadvertently filed in Guwahati, your lordship.
Unamia and who are, how many MSc cases are filed?
1 year.
One.
One.
Who has filed the case?
Your lordship. The petition has filed, but filed, that was given to the advocate. The advocate filed it in Guwahati, but it would have been filed in Shivsagar. I am from Shivsagar. I hail from Shivsagar. The accident and all that happened in Shivsagar, but the advocate inadvertently filed it in Guwahati.
So, appear.
Wait long for Shivsagar to appear.
Don't tell all this thing. You are 26 years old.
I am appearing for respondent 2 and 3. I have
You are in
also,
Shivsagar.
yes, I have also filed a similar petition for transfer, your lordship. That was also pending. That is also pending. From
Where?
here to Shivsagar. This is not tagged with this.
Okay.
Maybe tagged
This-
with this.
What is the number?
Transfer petition 21 of 2023.
List the matter. List the instant transfer proceeding, transfer petition, along with transfer petition C, number
21 of 2023,
21 of 2023
lordship.
on on 23 2020.
Oblige, your lordship.
20.
If any other state.
Will dispose of unnecessary.
If on 21 it's possible, lordship.
Why?
A Ganguly will be appearing, he will not be here on 20. Any other day. Any other.
Absolutely no. He's there to help you out.
Oblige.
Yes. Transfer from where to where?
From Biswanath Charlie to my lord.
Who are you?
My lord, I am the wife. And my husband, that is the respondent, has filed a divorce case, my lord, before the Biswanath Charlie, my lord.
Eh.
And it is very difficult for me because my lord, I am staying here, my lord, in Guwahati with my minor daughter, my lord.
Why you are staying at Guwahati?
Because it was very difficult for me to living with her, my lord.
Huh?
Live with the husband, my lord.
Understood. But why you are staying in Guwahati when your permanent resident is at Tinsukia?
Yes, because my lord, my child was studying in the school.
So you are going to stay here.
Yes, my lord, already I will draw one point, my lord. Already one maintenance case has been filed by me, and he has already contested it. And he has
Where?
in the family court, my lord, in Guwahati.
Where have you mentioned?
Yes, my lord, in my pleadings I have categorically mentioned, my lord.
Where? Okay, you do. FC.
In the lordship kindly see page number 4, para 7. But already maintenance allowance has been given me in 6,000.
But that matter is disposed of.
Yes, my
That
lord.
was disposed of at conciliation
Yes,
stage.
my lord, that is the fact. Matter is disposed. Now, my husband have no any difficulty because he has already appeared in that case also.
No, I have objected.
So, my lord, it is.
What do you do?
So, my lord, I have no any income, my lord. Only maintenance allowance has been given, and now I am, my lord, continue that maintenance allowance.
Have you filed your written statement?
My lord, I have, after receiving the notice, I have immediately filed an application under section 24 before the lordship. And accordingly, lordship has stated in a prima facie case, my lord, material is disclosed. my lord.
You transfer code 29(4). Appear before the principal judge out here, family court, and file your written statement.
But my lord, lordship kindly see it because my lord is inconvenient because my lord, I am also suffering.
Mr. Counsel, I am allowing your petition, and why you are saying this?
Yes.
You file your written statement on 29(4).
Our objection is there, my lord.
Objection, no objection, this time doesn't.
Actually,
You
my
want you want her to appear, then you pay them. Are you willing to pay around 7,500 per day?
No, only
When
thing is
they-
that is the.
Mr. Burwa, kindly tell me whether you are willing to pay 7,500 for the petitioner to go to Biswanath Sareli?
That is matrimonial home. She can reside in the matrimonial house. My father, mother That is the warehouse I have filed.
That is the problem she is facing.
I am saying that.
You are asking for restitution,
No, my lord.
divorce,
Divorce.
and you want a divorce, and she will go and stay at your place.
No, no, we are arranging that for her.
You are to, principal judge, you transfer করে দিন। 29/4, and you are going to file your written statement on that day.
Yes.
Well, earlier interim.
Vacated. It will go on that day.
Yep.
What is this? Steps not taken, also substitution not filed. Chalo. Unappeared when. None appears on behalf of the Crown Court. It is also seen that the petitioner had also not taken any steps, as is apparent from the office order dated 11/3/2020. Taking into account the above, this court is of opinion that the petitioner has lost interest in the instant proceedings, for which the instant proceedings have dismissed from non-prosecution in time order passed earlier than stated.
My pleasure, Lord.
Yes.
Lord, Lodgement Court Order 27/2.
What is this?
Reflects that respondent number 1 expired. So I'll take steps.
When? What is this application for?
So below the application for below for setting aside an order of restoration without giving us any notice below
Restoration of the suit.
appeal.
Now what has happened to the appeal?
Appeal is being postponed stayed without.
Why? There cannot be a stay. The delay has not been condoned.
Application by virtue of another application.
How?
Because one of the sisters has came before your lordship.
Now you know it has been restored. Go and fight out there. Unnecessarily, why you are filing this application? This matter is pending from 2017. My goodness. Mr. Sahu, go there. Withdraw this application. Unnecessary. Mr. Sahu, the learned counsel appearing on behalf of the appellant, applicant submits that, taking into account that the applicants now know that the appeal had been restored, the applicants would be more well advised to participate in the state proceedings. So taking into account, in that view of the matter, he submits that he would not rest for this interlocutor for this application for seeking condonation of delay. So accordingly, the instant condonation application stands dismissed for non-prosecution, for dismissed on withdrawal. In view of the dismissal of the instant application on withdrawal, the accompanying CRP being the accompanying revision petition being barred by limitation cannot be entertained. এখানে কোশ্চেন কোয়া নহলে মই CRP টো অর্ডার দিলো তেন ডিসমিস Yes, what is this?
I has been filed for condoning a delay of 327 days, like referring the second appeal.
Condoning the delay of
327 days.
in preparing the second appeal.
Yes, sir.
Then what has happened? Has the decree been executed?
No, yeah.
What decree was passed? Yes, you have filed objection.
Yes, sir.
What objection?
Because your lordship may go through the grounds they have shown, your lordship.
What ground they have taken?
If your lordship may come to the page 3 of the application.
When was the judgment and decree passed?
It was in
17 June 2017.
Huh?
17 June 2017.
17th of June 17.
2007.
It was inter partes?
Yes, sir.
It was inter partes?
Yes, sir.
Inter partes. Okay. Then what happened thereafter?
Lordship, in this case, the appellant.
What is the age of the petitioner? Petitioner died?
No, he has been substituted. His legal heirs are on record.
Understood. No, at the time when he filed, it was the petitioner was there. Now, what was his age? 52. Okay. How did he die? How did he die?
Lordship, he had several medical issues, so suffering from thyroid problem as well as hypertension and ankle pain.
Then,
He even had
thereafter,
issues
he
with
had
his urine
suffered
gas.
from multiple pain due to so and under such the petitioner after recovering from a contracted over in the month of and precisely and he was told by his counsel that his appeal has been disposed of. To know that the case was dead. Okay. Yes.
Lordship, if your lordship goes through the thing, the judgment was passed on 17/6/2017. After 5 months, he makes an application for the certified copy of the same.
The lawyer didn't inform.
Lawyer didn't inform. He has stated that he was in touch with the lawyer. He has given the phone number. Lawyer did not inform. He comes to Guwahati for his treatment. Thyroid, your lordship, due respect, thyroid problem.
He died.
No, he died subsequently, but this cannot be accounted. When he was very much present, he alive, he did not pursue the matter with due diligence. Because, your lordship, the case was passed on him because he was the plaintiff. He got
Effectively, it is a delay of 132 days. more than that, because there others happen because of all the other things which matter filed and all these things, defect and all these things. These are all not in there. The effective date delay is 130. To condone it.
But your lordship, due respect, there was sufficient negligence on his part, your lordship.
Understood. Negligence.
And your lordship
I
has,
don't consider this negligence till 500 days. After 500 days, yes, shocks the system. This is an application under Section 5 of the Limitation Act for condoning the delay of 327 days in preparing the accompanying second appeal against the judgment and decree dated 17/6/2017, passed by the Additional District Judge Nagaon entitled Appeal number 12/2013, whereby the appeal was dismissed. From a perusal of the materials on record, it revealed that the judgment and decree was passed on 17/6/2017. At that relevant point of time, the original applicant, one Ashish Chatterjee, bracket since deceased, was suffering from various ailments. He was only informed by his counsel on 25/11/2017 about the dismissal of the appeal on 17/6/2017.
no, your lordship, he came aware on 18/11. He makes a statement, 18/11, he goes to Nagaon, he becomes aware, but in spite of that, he applies on 25/11.
On 18/11/2017, telephonically, and thereupon on 25/11/2017, it was informed to him in person. Under such circumstances, the petitioner, the original applicants requested the said lawyer to apply for the certified copy, and the certified copy was obtained on 27/11/2017. Thereupon, the original applicant met
Certified copy 4/1.
Applied on Iman and was handed over to the petitioner on 4/1/2018. To the original applicant on 4/1/2018. Thereupon, the applicant came and met his counsel at Guwahati on 6/1/2018. The counsel at Guwahati informed the applicant that in order to prepare the second appeal, or in order to give an opinion and prepare an appeal against the impugned judgment and decree passed by the first appellate court, he would require the evidence, certified copy of the evidence and all other documents. Under such circumstances, the petitioner, the original applicant, could gather the same from his lawyer at Nagaon on 7/2/2018 and came to Guwahati on 11/2/2018. Thereupon, the second appeal was filed on 19/2/2018, which occasioned 132 days of delay. Be that as it may, although the said appeal was filed by the learned lawyer, but on account of certain defects, the said appeal was dismissed. The said appeal, what has happened?
The 3 weeks time was given to rectify the defects.
Huh?
3 weeks time was given to rectify the defects in the appeal, Your Lordship. Since steps were not taken within 3 weeks, the appeal was dismissed.
There was deficit court fees, your lordship.
There were certain defects. There are certain defects. in view of those defects, that the matter came up before the court, and by the order dated 27/2018, this court had granted 3 weeks' time to rectify the said defects. Full stop. This aspect of the matter was informed to the petitioner sometime in the month, sometime was informed to the petitioner in the first week of August. Full stop. And the petitioner could deposit the necessary amount only on 16/8/2018. But as the said amount was deposited, was given by the original applicant post 3 weeks, post the expiry of 3 weeks from the date of the order dated 27/2018, the said application filed by the petitioner was dismissed without any, in view of the order dated 27/2018. Thereupon, an application was filed by the petitioner on 24/8/2018 for restoration of the second appeal.
But if time and again the negligence is apparent, your lordship. And in your lordship's own judgment passed in recently, which is reported, your lordship has taken a strong view with regard to it.
Had filed an application for restoration of the second appeal along with a condonation petition. Now thereafter, what happened to that application for condonation application along with a restoration application with a fresh condonation petition? What happened there? Is this the
I came later on because it appears that it has been restored, I think. It has been restored with regard to that.
that was restored?
I think so. because
Then
I
the second appeal has been restored.
I have been recently engaged in this. From what I have gathered is, and another thing I like to point out, your lordship, the certified copy though was applied on 25/11. It was made ready on 8/12, but they did not receive it till 27 on till 4/1, your lord. So there was again a delay on their part because it was notified.
Further to that, it also revealed that it was on account of the health problem of the original applicant, which had resulted in the delay in filing the appeal, and thereby a delay of 327 days have occurred.
It is more than that, your lordship, as per the calculation.
Mr. A. Vishwas, the learned counsel appearing on behalf of the respondent, duly objects to the condoning of the delay, taking into account that thereby submitting that the said application which have been filed is mischievous and also do not explain the delay as is required under law. Full stop. This court, having taken into account the above facts, is of the opinion that the petitioner have been able to make out a sufficient cause for that the applicant have been able to make out a sufficient cause for condoning the delay. Accordingly, the instant application stands allowed. You have got a copy of the RSA?
No, Your Honor.
RSA.
Because that has not, only the filing number is given.
Filing number, RSA has been numbered.
I have not been
278.
served with a copy of the.
No, I think you want to give him a copy?
Give him a copy.
Give him a copy. The registry shall list the instant application, the registry shall list the I stands disposed. Economic লিখিব RSA 278/2018 heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, as well as Mr. A. Bitwas, the learned counsel appearing on behalf of the respondent, list the matter in the stage of Order 41, Rule 11 on 3rd of April 2020.
Obliged.
Is the matter of the completion of service.
Value.
Actually, wait, Your Honor. What if the thing has to be transferred? In view of the amendment to the, because the valuation, the RFA was 6 lakhs, 46 lakhs.
The learned counsel appearing on behalf of the applicant submits that the valuation of the suit being 6,23,770. The appeal has to be before the learned district judge. Accordingly, the learned counsel is given the liberty to file an application before the registry so that the registry can take appropriate action for transferring the appeal along with the interlocutory application before the appropriate court.
Add one more. The IA civil 675. We have filed an application for substitution because the opposite party number 1 has died. That is not tagged along with this.
I can't do anything. All these things will go there. I don't have the jurisdiction in view of the to do anything.
It was not tagged.
Whatever may be, you take it up. No.
As for officer, my lord, dated
Why you are not taking service by usual process? Why?
take it, my lord.
The learned counsel appearing on behalf of the appellant is directed to take fresh steps upon the respondents by registered as well as usual. What is this matter? Has there within 3 days from today? List the matter. There is no stay.
There is no.
You are paying for whom?
Respondent number 1.
This is service upon respondent number
3 and 4 is required. Proforma respondent.
2 and 3.
Proforma respondent 1 and 2. Sorry, my lord. are required. 3 and 4, sir.
Why do you need 1 and 2? 1, 2, and 3? Have they participated in the trial?
No, the respondent, pro forma respondent 1 is the husband of the respondent number 1. And others are the key.
Others?
Other respondent number, their son is the daughter.
Oh,
Pro forma respondent 2.
you have not properly mentioned the names also. What is 1 respondent and 4 pro forma respondents?
Yes, my lord. Pro forma respondent 1 is the husband of respondent number 1. 2 is the daughter of respondent number 1 with her earlier husband, my lord. And 3 and 4.
Have they participated in the trial?
My lord, they were party, my lord, but WS was filed by the respondent. Present
Were
respondent.
they the main defendants or pro forma defendants in the suit?
Pro forma. In the suit also. In first appeal also.
They were pro forma.
Pro forma. But pro forma defendant 1 was one of the witnesses for defendant side.
Witnesses, no
No, my
witness.
lord.
So they have not participated. Where is the necessity of them?
They have not.
So now you strike off their names. There's no necessity.
That's why I put the WS was filed by.
Forget about
Yes,
WS.
sir.
In your plane, you have only made this respondent as the pro forma respondent, defendant. Have you looked into the plaint or not?
Yes, sir. Plaint is there at page 7.
Plaint? There's only one. Why are you making those pro forma a party?
No, my lord, in plaint at page 7, plaint they were party. Page 7 of the arrest.
What is the second plaint?
Second plaint
At page 15?
is WS, my lord.
Okay. Lekho. Mr.
Yes, sir.
P.R. Sharma, the learned counsel appearing on behalf of the appellate, and Mr. A. Dhor, who appears on behalf of the respondent. This court have duly taken note of that the performer respondent numbers 1 to 4 did not participate in the trial, inasmuch as neither they filed any written statement and they have been shown as the performer defendants in the suit. Considering the above, this court finds no this court is of the opinion that the steps is not required to be taken as regards the performer defendant respondent numbers 1 to 4, and the instant appeal shall proceed only in presence of the respondent. List the matter appeal for hearing. List the appeal for hearing upon receipt of the LCR.
Yes, it is the service completed, but that was not come.
The office no more revealed that the AD card from the office memo, it is seen that the AD cards have been received from the respondent number 1 and 2. It reveals that the respondent number 1 and 2, the respondent number 1 is Sri Bhobesh Pathak, and the respondent number 2 is Sri Horen Dek Pathak. However, from the AD card, it is seen that one Junu Deka had accepted the said. Under such circumstances, this court is of the opinion that the said service through registered posts cannot be taken as due service upon the respondent. The appellants are directed to take fresh steps upon the respondent number 1 and 2 by way of registered as well as usual. What I
360, there is the office. IA 360, IA 360.
what is due?
There is a official also.
What is that?
24/8/2023.
Hmm.
Happy's report has been received on the response and the same has been sent. That's the one duly served. That's one of those have wife active.
Where? IA.
IA 360.
Service have been received by Iman duly served and so and so. No, that duly served cannot be the proper service. How can it be proper service? It has been received by some Junu Deka. You know who Junu Deka is?
Wife of the.
And they are Pathak. Unless you say something, take the steps.
They could also not come.
We'll see first take service. The registry shall also take appropriate steps for requisitioning of the
May I please, Your Lordship, I'm appearing on behalf of my domestic counsel, Your Lordship. Your Lordship, this is petition for the review of the Lordship order.
Why you are asking for review?
Your Lordship has been submitted a judgment here along with this petition, Your Lordship, is annexure number 2. Where it specifically says, Your Lordship, the relevant para, that is number 5, it says that order 27, rule 88, no security to be required for the government or a public officer in certain cases. In the case of Gujarat, the High Court observed that absolute stay can be granted in case of money dictate when the state is involved. It will be pertinent to mention herein that in Malwa Strip, Supra state was not involved as the appellate. The state of Kerala versus TK, Kuruvilla reported.
What are you reading?
Your Lordship, I'm reading the annexure number 2, Your Lordship, which I
What is annexure number 2?
here along with the review petition, Your Lordship.
What is this?
Your Lordship, it says that this relevant para is para number 5, which I am reading, Your Lordship.
Okay. Therefore, this is an application seeking review of the order dated 14/9/2022 on the ground
Lordship, may I submit here? Lordship, in this regard,
Don't worry, I'm dismissing it right away.
Lordship, this is not permissible in view of the judgment of the Honorable Apex Court.
PEM development.
Yes.
Yes. This is an application file seeking review of the order dated 14/9/2022 passed in IA Civil 256/2022, whereby this court state the impugned judgment and order dated 23/4/2021/36/2021 passed in O.A.O.A. -Roman 3-127/2014, subject to deposit of 50% of the decretal amount along with interest within 6 weeks from the date of the said order before the registry of this court. Further to that, this court, by the said order, directed that the claimant gave the liberty to the claimant to withdraw the said amount by filing the appropriate application along with an indemnity bond. The learned counsel appearing on behalf of the applicant submits that in view of the judgment passed in by the division bench of this court in the case of Commissioner and Secretary, bracket power and others versus Shaman Enterprise, bracket M/S, bracket close, reported in 2010 3 GLT 126. This court is required to review the said order. This court have duly taken note of that the recent judgment of the Supreme Court in the case of the judgment of the Supreme Court in the case of
Reported in 2019,
judgment of the Supreme Court in the case of PAM Developments,
PAM Developments Private Limited versus
Versus?
State of West Bengal,
State of West Bengal, reported in
2019, 8 SCC 112.
and is of the opinion that no review. Is of the opinion that the instant application seeking review is totally misconceived, for which the review application stands dismissed.
Your Lordship, just one question that on the basis of this particular context submission on MFA 3 of 2022, this honorable court has disposed of the application. Your Lordship. This honorable court has passed an order in MFA 3 of 2022.
This court?
No, Your Lordship, other court.
Oh, go to other court. For me, this is review.
Obliged.
The MFA to you come in it.
Item 24.
What happened?
I thought I have fully responded.
Respond number
1
and 2. The applicant, the none appears on behalf of the applicant on call. Mr. N appears on behalf of the respondent. He also submits that an affidavit in opposition has been filed to the application seeking condonation of delay. For the ends of justice, the matter stands adjourned to be listed again on 3rd of April 2024. It is made clear if the respondent is not, applicant is not represented on the next date, the instant application shall be dismissed or not.
Okay.
25.
Taking into account that the service is complete as well as the LCR has been received, list of appeal for hearing in its usual format. Same order. 26, na? Same order.
Hello.
Wait. Have been served. It order to NK about 26. The learned counsel, taking into account that the service upon the respondents are duly complete and the LCR has been received, list the matter for hearing in its usual 26.
7.
Yes.
Lordship, I am appearing for sole respondent, respondent number 1.
So respondent.
Yes.
LCR received. Okay. Taking into account that the service is complete and LCR has been received, list the matter for hearing in its usual course.
Yeah.
Affidavit in opposition has been filed. I file a reply.
What? What is this affidavit in reply and then he'll file a rejoinder and then a third rejoinder? Why not? Let us make it bigger and bigger. Huh?
Paragraph 8. 16,
Why
and
this
there I have
delay?
reply. Lord,
Why this delay?
delay because of Lord,
When was the judgment passed?
judgment was passed, Lord, on
26/4/2018. 3 weeks time granted to the applicant for filing of affidavit in affidavit in reply to the objection filed by the applicant, respondent. 3 weeks. The fit case for dismissal.
There is an 85 days delay in citing that.
You are paying
My lord, we have filed the objection, my.
by the relay
85 days.
85 days. Okay. It is an application file.
My lord,
Madam,
I have a submission to
Madam,
make, my.
Yes, tell
I
me.
have filed the objection, my lord. If your lord could kindly see the delay is not 85, my lord. It will be much more than that. We have given the calculation at page number 10 now of the record, my lord. Page number 10. It is actually 208 days.
COVID that
He gets the benefit on the 2028 to 2022. He gets the benefit. So there those days goes, no?
But that has not been pleaded, right? That is not the thing, right? That is not the explanation. COVID
No, it's
period is
okay. I appeal to some. Delay to connect. Date of the judgment 28/10/2021. Date of filing 2022. So and so to Iman 209 days is taken out. Limitation 90 days. Total is 119 days. 34 delay. Yes. This is given properly.
but that COVID thing, my lord, that is not the reason shown here, my, in the application.
He is otherwise entitled to. That's the law. Everywhere it is being given. You can't help that.
And regarding that, my lord,
You have a case, I suppose, in the second appeal, or you don't have it? This is an application under section 5 of the Limitation Act, read with order 41, rule 3A of the Code of Civil Procedure 1908, seeking condonation of the delay of 85 days in preparing the accompanying second appeal against the judgment and decree dated 28/10/2021, passed in title appeal number 3/2015 by the Court of the Learned District Judge, Bongaigaon. This court have duly taken note of the grounds which have been assigned in the instant application. Further to that, the objection so filed by the respondent have also been taken note of. After hearing both the parties, this court is of the opinion that the grounds which have been assigned in the application constitute the sufficient cause within the meaning of Section 5 of the Limitation Act. Accordingly, the delay stands condoned. The registry is directed to register the accompanying regular second appeal and list the matter in the stage of Order 41, Rule 11 on such date as deemed fit by the registry immediately after the Bihu vacations.
Okay.
30.
Yes.
May I please? This is a condonation of delay of 375 days, excluding the COVID period.
COVID period?
If it is not excluded, then it
When was the judgment passed?
judgment passed on 4/5/21. Decree passed on 4/5/21. Judgment passed on 3/2/20.
Judgment passed in 4/2/2021, appeal filed on 8/6/2023. 1/3/31 is 56 days. Limitation 90 days. Why the registry have not taken into account that period from 2002? Have they taken? Oh, okay, they have taken. $375, please. Yes, you are appearing. Will file of objection or you have no objection?
I'll file objection, Your Lordship. Objection will file.
Mr.
Your Lordship, these are
issue
government
notice
first land.
making it returnable by 4 weeks. Full stop. As the respondent is duly represented by friends of extra copy of the instant application be served upon her within 2 days. The respondent shall file their objection, if any, against the said application.
Apply, sir.
31. The sole respondent died and the appellant number 1 also died. But appellant, other respondents of the other appellants are already in the appeal. So, but the respondent, the name of the sole respondent, legal heirs of the sole respondent is for my lord.
Who died?
Habar Ali.
Abdul Ahad is alive.
Yes. Habar Ali died, my lord.
Who died?
Habar Ali.
Who is Abur Ali?
The respondent.
The sole respondent. And
Then
the-
she has been restored. The substitution done.
Yes, sir.
No, I've received a copy. I filed a vocal number. There is a date fixed for this order on the substitution petition.
On what petition?
Substitution petition on section 5 application.
This is a petition for what?
Well, in fact, some people.
Application for stay of the impugned judgment and are passed in civil appeal number and further stay the execution case. Has the appeal been admitted?
No.
No, my lord, not yet.
Then how can that be possible?
Both the courts.
List the appeal. List the appeal. Service is complete.
Yes.
Taking into account the service is complete, list the appeal for consideration in the column of Order 41, Rule 11.
Oblige.
Your lordship fixed a date.
You have urgency
No. I will not be.
on such state immediately after the Bihu.
Please, Lord. The IA 2155 file, my lord, for striking of the respondent number 15 to 30 and 44, 45, because now they did not participate in the trial and the appeal, my lord. And my lord, for which I did not take my leg against the respondent and file this IA, my lord, for striking of the area of the respondent. Page number 14.
This is an application filed by the applicant for striking out the name of the respondent number 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 45, and 44 and 45 on the ground that the said respondent did not contest in the suit as well as also in the appeal. Taking into account the above, the names of the said respondents are duly struck off at the risk of the appellant. The appellant is directed to file a fresh amended memo of parties before the registry of this court within 3 days. I stands disposed.
This is an application for implementation of the legal heirs of respondent number 4 who died before we could file the appeal, regular second appeal.
This IA number 25326.
2526.
Yes, what is it?
It's an application for implementing the legal heirs of respondent number 4 who died before we could file the regular second appeal. He died on 27.
Who died before the filing of the regular second appeal.
Yes.
Then?
But we inadvertently we errate respondent number 4 as a party respondent here.
Then?
In place of him, my lord, this 1, 2, 3, the legal.
How can you do it under order 22 rule 4?
It is order 1, rule 10, 2.
You want to implead them.
Yes.
Why?
They are the legal heirs of respondent number 4. He is the defendant in the suit.
What was the suit for?
A suit for declaration of right title and interest and recovery of possession. There is a counterclaim from the side of the defendant.
Who is in possession?
My lord, the defendants are in possession.
These respondents are in possession.
Yes.
Where is it mentioned? In your application?
In the application, we have not mentioned it.
Then how do you know that the right to sue survives upon them? Isn't it the requirement that the right to sue has to survive against the defendant, or if there is no other defendant, the right to sue against the remaining defendant does not survive?
The plaintiff filed a suit for declaration of right title and interest.
You are the
It should-
defendant.
I am the defendant.
You are the defendant.
Yes. In the suit, I am the defendant.
The suit has been decreed.
Decreed. We filed an appeal. The appeal was dismissed. Against that, my lord, we have filed a particular second appeal.
So these people have now they are enjoying.
Yes.
Now, when did that person die?
The person died on 27/3/2020.
Huh?
27/3/2020.
And when was the first appellate court judgment?
28/5/2019.
And you filed the appeal?
24/6/2020.
24/6/2020. Okay, you didn't know that. Inshallah. This is an application.
Respondent number 1, 2, 3, 5.
You are not poor.
No.
This is an application filed under the provisions of Order 1, Rule 10(2) of the Code of Civil Procedure to implead the legal representative of the respondent number 4 who died pursuant to the judgment and decree passed by the learned First Appellate Court in title appeal number 14/2018 on 28/5/2019 and before the filing of the accompanying appeal on
24/6/2020.
24/8/2020. No, 24/6/2020. This court, taking into account the provisions of Section 146 of the Code of Civil Procedure, is of the opinion that this is a fit case for impleadment of the legal representatives of the respondent number 4 who expired after the decree passed by the First Appellate Court and before the filing of the appeal. Accordingly, the legal representatives of the respondent number 4, whose name appears in paragraph number 2. What is the address?
Well, address would be the same, my lord.
Where is it mentioned? This
My lord, this
application.
page 2.
No, address is not given.
Page 2, my lord.
Where is it?
Page 2, all are the sons, all are residents of Iras, Jungle Gaon, EONPS, Dhirajuli, Munda,
Ruma Dev, Dhiraj Dev, Aman Dev.
And
Where are they?
and Sanju Dev, 4.
Where?
Well, serial number 4, page 2, serial number 4, 3, Sanju Dev.
No. You have to make these people, their address is what?
Well, same address.
How do you know?
Well, here's the wife. They are the wife and
Wife may left it. You said it.
They stay together. But
No. File an additional. It's the matter after 2 weeks. In the meantime, the applicant shall be at liberty to file an additional affidavit stating the address
well, if I
of
may
the legal
take your lordship to
representative
page 3,
of
where-
the respondent number 4.
well, page 3 we have mentioned.
No, it's not.
Page 3, kindly my lord, have a look at the page 3.
Because
36.
Your lordship.
you have to take fresh steps upon respondent number 1
Yes, Lordship will be
and 4.
dusty Lordship, because the office note says that addressee left, but they are there. They are the claimants and they are
You want to
pursuing.
take dusty service?
Yes.
Ms. R.D. Majumdar appearing on behalf of the appellant, applicant oblique appellant submits that the applicant may be permitted to take dusty service upon the respondent number 1 and 4, taking into account the above this court.
No,
fixed-
4 Lordship, he has already died. We'll strike out. He is the one of the drivers. 4 has
He
died.
died.
Yes. Address. 4 addressee expired.
Okay. The learned Ms. R.T. Majumdar, the learned counsel appearing on behalf of the applicant submits that the applicant may be permitted to take steps upon the respondent number 1 by way of dusty. Accordingly, list the matter again on 22nd, 24th of April 2024.
We need earlier date, Lordship, because they are pursuing a money acquisition there. And this is a delay petition. So if within this week, we can give just after holy holidays, any date.
Today is 18th. I can't have it on 18th. We can have it on 18th of April, nothing more than that. 1 month has to be.
Nothing before that.
When did you file the appeal?
We file in 23. Lordship.
And then when the matter comes up in 24, you have the urgency.
No, Lordship, no, in the meantime, I'll do the necessary thing for the money execution.
On 18th, list the matter on 18th of April 2024. 19th of April 2024. On or before the next day, the learned counsel appearing on behalf of the applicant shall file an affidavit of service. As regards service of notice upon the respondent number 1. As regards the respondent number 4, the learned counsel appearing on behalf of the applicant submits that as the said addressee had expired, as could be seen from the office note, his name may be struck off. Taking into account the above, the name of the respondent number 4 is struck off at the risk of the applicant. As regards the service upon the respondent number 2,
You have to await.
the same still await.
And put a respondent number 3 here, but
and put a respondent number.
Give your name. Yes, what are these?
My lord, it for IA is not for modification, variation of order, my lord, under order 39 rule 4, my lord.
Huh?
Order 39 rule 4, my lord, an injunction order was passed, my lord, against this applicant, my lord, who is not a party to the, my lord, court.
Who passed it out?
Honorable court. Honorable court.
I passed.
Not your receipt, my lord.
Where?
And it was
Which
passed,
order you are referring to?
my lord, order
Hey, main case. Where order has been passed?
my lord, 29-1.
You have varying and area 21-9. Where is the 21-9 order?
My lord, page 65.
Page
65 in relevant page, my lord.
65.
Page
65.
relevant 72, my lord.
Yes.
My lord, in fact, my lord, the respondent number 8 is my lord, owner of LN. My lord, the dispute is between respondent number 1 to 7 and 8. 8 is my lord.
Let it come up before that judge who passed that order.
That judge has recused himself but Justice P.J. Saikia has passed the order. Subsequently, Justice Saikia has recused himself from this.
What?
That is why.
That is why the matter is before me.
Yes. On last occasion, it was before Honorable Justice Karta Gete. Matter was heard. Then.
What is this matter? Hey, second appeal. What is this? Second appeal or what?
Second appeal.
Tell me, what is this second appeal?
My lord, my lord, that suit was filed by.
How many second appeal? One.
Only one.
My lord, I have
My
just
lord,
so
what
many IAs are there. I have just prepared a list of IAs. It may be helpful.
So many matters are there.
This list may help, my lord.
This appeal, whether further was justified in setting aside the judgment and decree passed by the trial court granting the relief of partition on the face of the pleading that the predecessor interest holds her land, measuring which was gifted, whether the granting of relief to the respondent without considering the fact of gift to the daughter. The comment. So, we dismiss the second appeal. Matter ends. Thereafter, do whatever you like. Yes. What appeal you have?
I have not filed that.
Who has filed it?
I am only for IA.
Who has filed the appeal?
My friend is for.
And who are you?
No, I am in my lord.
What is his locus, my lord?
I am in IA.
Who are you?
I am a stranger, my lord.
Stranger, what does he have
No,
been in business?
my lord, the appellant has entered into an agreement with me, my lord. He allowed me to a part of his land to construct a building, my lord. I started construction of building, my lord, in the agreement was made in the 2018, my lord. I started construction 2020, my lord.
Have you become a party to the instant appeal?
No.
Then?
But my lord, my lord, then my lord, the order is defecting me, my lord.
What?
My lord, the dark number on this I am making construction, my lord. These dark number are not, my lord, part of.
Who entered into an agreement with whom?
Appellant.
You entered into an agreement with him.
My lord.
Now the order has been passed.
My lord.
Thereby it is being affected, whereby there is a direction not to construct.
My lord.
And you have not become a party.
But my lord,
Without being a party, can you do so in this proceeding?
No, my lord, since the order is against me, my lord, because
order is not against you, order is against him.
No, my lord, the dark number, patta number on this I was allowed to construct, my lord, those dark number, patta number are not the part of suit lane.
Huh?
Those dark number in patta number are not part of the suit lane. Without, my lord, without.
Who is the plaintiff?
Plaintiff.
We are the,
Without.
we are the plaintiff, my lord.
Wait.
We are the plaintiff, my lord. We filed a suit.
Let us see the judgment and decree. The decree has to be in the particular, the decree has to say, what is the decree for?
Partition, my lord.
The decree will contain various lands.
Plenty is there.
6 acres of land out of the total land in dark number Iman in so and so. Schedule B share of the plaintiff mother with so and so. 1/4 of the schedule land which equals to Iman. Plaintiff share to be partition. 8/9 of the share of schedule B land. So,
page 80, page 80, on page 80 of my IML schedule.
which I
2730.
2730. Yes.
Page 80, my lord.
80.
Schedule A is the suit length.
Six bigas, 3 kathas, 17
Let
lectures.
us of the total length in PT number census, my lord. Dark number census, no state boundaries given, my lord. Then it will be 1/5 of 1/4 of fair in the.
Now, this patta number 97,
My lord.
did it become patta number 674?
No, my lord. Yes, 91, 97. You know, 240, 97 become my lord 241.
Huh?
Patta number 97 became later on 241, my lord. And,
241.
my lord. And
So here the direction is
my lord.
new dark number 8130 of new patta number 674, the superintendent area. No further construction.
My lord.
You are only worried with that.
Right.
But that is not a part of this
No, my
schedule.
lord. Oh, two control it is not. First, my lord, they send the dark number without, my lord, without making any amendment. My lord. They send this new dark number, my lord, in the IM. And my lord, here the boundary is also not given, my lord. They file an IA, my lord, giving the boundary of my land, my lord, or this I am making the construction. My lord, without any amendment, my lord, how they can be allowed to, my lord, change the schedule of the land and my lord, the dark number.
No. Therefore, the question is as to whether dark number 8130 of new patta number 674
My lord.
is a part of the suit land.
No, my lord. Because, my lord, in this plaint itself, my lord, they have not claim partition over a land, my lord, that was gifted to this appellant. That was gifted in that 1965, my lord, by a registered gift, my lord, and there is a statement, my lord, this page 79.
No, understood everything.
My lord.
I'm asking a simple question. This order only operates as regard dark number 8130
My lord.
of new patta number 674. As to whether this 674 patta comes out of dark patta number 97.
Yes, it comes, my lord. It comes, my lord. But my lord, the land of this particular dark and patta, my lord, it was gifted to the appellant, my lord, in 1965. And the plaintiff, my lord, claimed that they are not taking any partition on over the gifted land.
Where is it?
It is in para 15 of my lord, page 79.
Para?
79. 79, my lord. Just go one page.
Yeah.
79. Para 15.
Since plaintiff not admitted the gift as a valid, and share of the plaintiff in gifted land also included in the state notice as available right for partition. But in this case, said gifted land and plaintiff share thereon is abandoned, reserving right to claim the said share under the process of the law separate. Mr. Gaur, first of all, in a civil proceeding, you can have no say. Your right only arises from here.
My
He may say.
lord, he may say, but
If he has not done anything, you take up action for breach of contract or whatever may be, that is your thing.
no, my lord,
But as of now, you have no, unless you become a party to the proceedings. Now, in the instant proceedings, you may be a party or whatever may be, you may come under the ambit of Order 22, Rule 10, on the basis of being assigned.
yes, yes.
So you may come, but why you are not becoming a party? Without becoming a party, how can you?
My lord, but my lord, perhaps my lord, order 39 rule 4, this order is affecting me, my lord. I am.
But you are not a party.
No, that's why, my lord. That's why, my lord, without hearing me, this order is, my lord.
How can there be a party? This land, he's not passing an order to that effect. The order only in respect to this would be applicable. And how is the superintendent being asked?
No, my lord. Yes, my lord. And my lord, without my lord, whether this is a complaint or not, my lord, and superintendent of police, my lord, asked, my lord, in the IA, they made a prayer, my lord, that the revenue authorities should be directed to, my lord,
What is this 2911? Let me see. Where is the 2911 order?
that is, my lord, page
840 को review petition. IAC आपको 840 Mr. Very difficult to find out the people. Now, this order which have been passed in this application, IA 1130, where is that?
my lord. That application is there.
1130. What is this application?
My lord, in this application, my lord, they paid for, my lord, a report from the revenue authority, whether the construction is going on the shootland or not.
What is this proceedings, Mr. Das? These proceedings under you filed 1130?
1130, this is for police assistance matter.
Huh?
Police assistance.
Why?
Because initially an injunction order was there. Injunction order was not complied with. Then we filed this.
Whether it has been complied or not, that is a question of subject matter. Yeah. How could this order be passed?
Rightly or wrongly, that order has been passed.
We vacate this order.
The police
No,
report.
this order cannot remain. How could the police be brought in? The police is being brought in under order 21, rule 35. Nothing more than that.
Even for my lord, implementation of an injunction order, my lord. Police
Under what
assistance-
provision?
Under 151, my lord. Under 151, my lord, the court can pass an order for police assistance for implementation of an injunction order, my lord. So, my lord, when an injunction was passed, injunction order was not complied with. Then we filed this application 1130. 1130 was for police assistance. Now, police assistance, because of this police assistance.
What is your prayer? Let us see in 1130.
Page 62. My lord, before going to that.
No, we are going to this.
Yes,
Please
2730.
admit the Iman, direct the so-and-so to ensure compliance to the order dated so-and-so by this court by calling for a fresh report.
Yes.
As regards the actual Gonza over the land and so-and-so in the pleadings made in the objection dated and also the review petition and B plus. So you are only asking for a fresh report.
No, to ensure compliance of the order dated 29/11/21.
By this court,
Yes.
by this court, by
Passed
calling for a fresh report.
No, my lord. I'll just read it again. It is therefore prayed that Jorhat and the SP direct the Deputy Commissioner Jorhat and SP Jorhat to ensure compliance of the order dated 29/11/21, passed in IA 840/2021. Then 840/2021 is an injunction order, my lord. The order which was passed in 840/2021, that was an injunction order. In spite of there being an injunction order, when the construction was going on, so this 1130 was filed. And subsequent to this filing of 3130 and order 1130 and order was passed. Now he has filed and moreover, my lord, this 2730 he has filed on behalf of a builder. And this petition, this IA 1130, this review petition, and on behalf of the land.
Who is violating?
No,
who is violating? Who is violating the order?
The appellant, my lord.
Who?
The appellant.
Okay. We will say that this order shall
the
be only.
appellant
No,
because-
Mr. Das.
No.
We will consider because this order, this is an order passed in a connection between you and the appellant.
Now that is. Now
And
what
as
is now
such,
in
you
2730,
no,
my lord.
under such, is there any allegation in your application that he is constructing?
No, what is his now without now, my lord?
Forget about the
let
other
us-
thing.
Let us assume that, my lord.
We
there
are
is no, my lord,
therefore
allegation.
saying that this order shall only be effective against the parties to the suit, not.
Now he has, my lord, he has entered into an agreement with the
That was much.
respondent
Who is
number.
constructing?
My
No,
lord,
Mr.
through,
Mr.
because now
Das,
he is
who
the agent, my lord.
No,
He is the
Mr. Das,
agent,
who is
my lord, of the
constructing?
principal, my lord. Who is the principal? Respondent number 8.
No.
And what is his
Is
prayer?
he a
without
party to the suit?
This
Mr. Gaur.
no, well, he is not. So now
Under
without
such
being
circumstances, is there any allegation
My lord,
in what?
we-
No,
my
Mr.
lord, the
Das,
order says-
no, Mr. Das, kindly listen to me. Whether there is any allegation in 1130 against the applicant. No. We clarified that. That this order shall not be effective insofar as
Mr. Gaur has entered into a development agreement with the respondent number 8, my lord. Now, that being the position, the respondent
did
number
you
is
make an allegation to that effect in the application?
under 1130.
No. Absolutely no. When did you enter into an agreement?
2018.
Then?
They were aware of it.
Then have you mentioned it?
Yes, my lord, I page 10.
8,
Page 10, para 4, start from page 9. My application.
para 4, page 10.
Page 10, gravely affected and caused undue hardship to the applicant.
Page 10 doesn't have any data.
No, it para 4 start from page 9, and
No. His application 1120. Where is it mentioned?
1120,
1130, where there is
No,
mentioned.
1130, there is no.
Well, this order cannot be therefore effective against them. No.
No construction be carried out by my lord respondent number 8 or anyone acting through them, my lord. Because
No, you have not made them a part. No, this order.
Yes.
I'm saying this order, you knew it. He's constructing. Why haven't you made him a party or said that he is constructing? In the guise of this, you have taken an order against him.
because my lord, he gets the power through the respondent number 8.
So what?
Now, if he gets the power, now if the respondent number
Are you
8
saying that by entering into an agreement,
Yes, ma'am.
he becomes principal and agent?
No.
No.
Because he
These are both independent entities on the basis of the agreement itself.
now, my lord, the respondent number 8 has given him the authority. By virtue of that authority, he is developing that land, my lord.
That is not a virtue of the authority. He has an agreement. On the
By
basis of
virtue
that agreement,
my
he is
lord,
doing
that
it.
is why-
But
by
the
vir-
agreement was entered into in 2018.
Yes.
And in this 2018, at that point of time, you had started the construction. You filed this appeal in 2020. 20?
Yes,
20. Then
Well,
why haven't you not mentioned it? You cannot have that to that effect. We may clarify this order shall be applicable, however, shall not apply insofar as the applicant.
now, my lord, first of all, what is his prayer in 2730?
Clarification.
Yes, it's 2730, that is implement application. He seeks, my lord, page 22.
Hmm.
Now, without being a party, my learned friend has referred to that order 39 rule 4. Now, order 39 rule 4 says that party. Now, he says that it is therefore prayed that your lordship may be pleased to admit this petition, issue notice calling upon the opposite parties to show forth as to why the applicant should not be impleaded as a party to the proceeding, which proceedings, ma'am? And as to why the order dated 21/9 directing the SP Jorat to stop further construction on the land covered by so and so should not be recalled or
Don't
modified
worry.
or said.
We will convert these proceedings to a proceedings under order 22 rule 10.
Yes, let
Then
him work.
no, it is there. The prayer is there. The application is made under order 1 rule 8A and 10. And on the basis of order 8, order 1 rule and 10, we implead him and then say that as there was no allegation out that order does not apply to him. Why haven't you made him a party?
So, it will again lead to multiplicity of proceedings, my lord.
You knew it very well.
Is a multiplicity of proceedings, my lord, because his right has flown from the 8 number 8.
Let it be.
His
That
right
you-
is not
you-
independent.
You see,
He doesn't have any independent right in this.
first and foremost, you get an order of whatever injunction out there.
Yeah.
That he no construction. You come up before this court. Don't mention that he is constructing.
Well, there is an arrangement between himself
So
and the
what?
respondent number.
Are
Respondent
you
number eight.
saying that you don't know?
Now, who is my lord carrying out the
Mr. Das,
construction,
you
my
saying that you don't know.
Yeah, maybe it may be lack of knowledge, my lord,
Okay.
because it is.
So
an
we will
agreement-
say that you did not know.
My lord,
I was going to say that you did not know.
may not know, my lord,
No,
because
Mr. Das, Mr. Das, no.
agreement, my
I'm asking you a very specific question. Are you saying that you don't know?
My lord, this plaintiffs, they may not have known.
No. I'm saying whoever had moved that application 1130 say that they don't know that he is constructing.
My lord, page 850.
Forget about that. Are you saying that? And if that be so, then we will say that he having not known this order, they did not imply in their application about them.
Who have
And
this
accordingly, we will consider.
application was moved.
IH civil number 2730/2023. This is an application filed by a third party seeking vacation, modification of the order dated 21/9/2022 passed in IA Civil number 1130/2022. This applicant had enclosed to his application an agreement dated 4/1/2018 entered into by and between how many second appeals are there?
Only one.
His appeal.
Is it?
And you take the injunction.
Because I am the plaintiff. Suit has been, my lord.
So what?
My lord, I am the plaintiff, my lord. Suit is decrease in my favor, my lord. Suppose tomorrow the property
Okay.
is
Had-
disputed, the plaintiff
From
should
the
suffer, my lord.
year. See? The appellant in RAC number 90 of 2020 and the applicant for construction of a multi-story building,
My lord.
in a plot of land measuring 4 katha 12 lechas covered by dag number 8130 bracket old dag number 7169 bracket close of periodic patta number 674 bracket old PP number 241 under ward number 16 you were given for A and B or no, only B,
Only people.
only B. Old PP number 241 under ward number 16 under Jorhat Municipal Holding number 99 of Jorhat Town, Moja number 9 in block number 10, Jorhat. On the basis of the said agreement, the applicant started raising construction over the said land, which have been more specifically described in Schedule B to the said agreement dated 4/1/2018. In the said backdrop, this court now finds it relevant to take note of the history of the present proceedings. The applicants, the respondents in the second appeal as plaintiff had filed a suit being title suit number 16 of 2010 seeking declaration that the plaintiffs have right of inheritance over the suit property with right of mutation and partition, semicolon, for passing preliminary decree semicolon, for passing final decree for recovery of khas possession of Schedule C land and for permanent injunction against the defendants, restraining and prohibiting them, their servants, agents from interfering with the use, occupation, possession, and enjoyment of the share of the plaintiffs in any form and manner. This court further finds it relevant to take note of that Schedule A land as described in the plain is 6 bighas 3 kathas 17 lechas out of the total land in PP Patta number 97 old 241 new of Dag number 7169, 7170, 7172, 7171, 7134, 7162 of block number 10, Jorhat Town, Moza. Schedule B is claimed to be the 1/4 share in Schedule A land, which is equal to 1 bigha 3 katha 9 lechas. Schedule C is the plaintiff's share to be partitioned, that is 8/9 share in Schedule B, that is 1 bigha 2 katha 10 lechas out of Schedule A land, and as per land revenue regulation. It is relevant to take note of that there are no boundaries mentioned in the said suit land. Another very pertinent aspect which could be seen from the plaint itself more particularly at paragraph number 5, paragraph number 4 and 5. There is mention that in the patta number 241, various lands were sold and after the sale, certain quantities of land remain. And in DAG number 7169, 3 bighas, 2 kathas, 12 lechas remained.
No, my lord, 1 bigha, 3 kathas.
Mr. Gore, don't disturb. It is further seen from paragraph number 5 that 2 bighas, 4 kathas, 4 lechas in DAG number 7169 was transferred, was gifted. We are concerned with 7169. Then how much land remained?
My lord, after sale and gift, my lord, a para 6, my lord, 1 bigha, 3 kathas, 16 lechas remain in this DAG.
Huh?
In same, my lord, para 6, my lord. After, my lord, sale and gift, my lord, 1 bigha, 3 kathas, 16 lechas remain for party.
How can it be?
My lord,
It cannot be.
yes,
That's a calculation mistake. You see,
yes, my
paragraph so
Yes.
after the sale of the aforesaid land, the land remained in DAG. Number Iman is Iman. So
Yes, ma'am. Yes,
7169,
yes,
3 bighas, 2 kathas,
Ma-
12
yes,
lechas. So this gifted was 2 bighas, 5 kathas, 4 lechas. So therefore the remaining land was 3 bighas, 2 kathas,
3 kathas,
2 bighas, 4 kathas. 312 minus 200. Three kathas, 8 lechas. And land measuring 3 kathas, 8 lechas remained. This calculation at 6 is wrong. 3 bighas gift, 3 bighas and gifted 5 bighas and 1 bigha remains. How is it possible? It is also seen in paragraph number 15 of the plain that the gifted land and the plaintiff share thereon was abandoned, reserving the right to claim the said share under the process of law separately. The said suit in fact, the entire claim of the plaintiff is wrong then. If you see 6, it is wrong. It can't be this.
Yes.
If it can't be this, there cannot be 6 because
Yes.
because they have based it on 1 bigger 3 katha, which should have been 3 kathas, 8 lectures. It is seen that the said suit was decreed.
No, suit was dismissed, appeal was there.
The said suit was dismissed by the judgment and decree dated 31/5/2014. An appeal thereagainst was filed being title appeal number 9/2014. And the learned court of the additional district judge Jorhat held that the plaintiff are entitled to the right title and interest in respect to 1/4 share equal to 1 bigger 3 katha 9 lectures of the land described in Schedule B out of the Schedule A land, and 8/9 share in Schedule B land, that is 1 bigger 2 katha 10 lectures out of Schedule A land. Against that, the present appeal has been filed by the appellant, and this court, by an order dated 4/9/2020, admitted the appeal by framing 2 substantial questions of law. The record reveals that in the said appeal, where is the first injunction? How did this matter come?
Well, they file an IA, respondent file IA 840.
Where is that? 840. Is a review petition or a file? We got it. The record reveals that an application was filed by the respondent as applicants, being ISC 840/2021. And this court directed the respondents not to undertake any construction or further construction in the suit land till the disposal of the second appeal. The respondents were also directed not to change the nature and character of the suit land, nor will they alienate any part of the suit land till the disposal of the connected appeal. This court at this stage finds it very relevant that in the said application so filed by the respondent, a statement was made in the said application to the effect, more particularly at paragraph number 11, the opposite party number one, that is the appellant herein, had entered into a negotiation with a builder, namely Govardhan Atal, for developing the entire suit land without even waiting for the outcome of the RSA number 90/2020. And the petitioner and the respondents herein had attempted to contact the opposite part appellant to inform him about the impugned steps taken by them, but the appellant herein flatly refused to meet the respondent. It is under such circumstances the said application was filed. Thereupon, various applications were filed and by an order passed in ISC 1130/2022, this court passed an order on 21/9/2022 directing that no further construction should be undertaken in dark number 8130 of new Patta number 674. And the Superintendent of Police Jorhat is directed to stop further construction on the said land. This court have duly taken note of the application being IHC number 1130/2022. And from a perusal of the said application, it reveals that it was alleged that the inquiry report submitted by the Deputy Superintendent of Police needs to be revisited. And a fresh report may be called for to show, as to whether the appellant had violated the order dated 29/11/2021 passed in IS Civil number 840/2021. It was also alleged that the inquiry report dated 31/3/2022 is not based upon the actual facts and is contrary to the pleadings of the appellant herein. Surprisingly, the said application is completely silent. The applicant herein has been constructing It is under such circumstances. No, it is also relevant to take note of that in the said application, the relief sought for was that the Deputy Commissioner, Jorhat, and the Superintendent of Police, Jorhat, should ensure compliance with the order dated 29/11/2021 passed in IA Civil number 840/2021 in RSA number 90/2020 by calling for a fresh report as regards the actual position of construction over the suit land by bearing in mind the stand of the appellant in his pleadings made in the objection filed in IA Civil number 840/2021 as well as the review petition number 11/2022. This court further finds it very pertinent to take note of paragraph number 10 of the said application being IA Civil 1130/2022, wherein it has been mentioned that the appellant had, however, stopped construction over the suit land. Therefore, the prayer which was made, having taken into account the pleadings, has to be taken that the Deputy Commissioner or as well as the Superintendent of Police was asked to submit the report or for that matter, revisit the already submitted report dated 30/3/2022. It is under such circumstances the order dated 21/9/2022 was passed by this court stating that no further construction should be undertaken in new dark number 8130 of new Patta number 674. And the Superintendent of Police Jorhat was directed to stop further construction on the said land. It is under such circumstances the instant application has been filed. This court, after taking into account the above materials on report, LC has come.
Yes. 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 Yes.
That prima facie, it appears that there is no materials on record that this dark number 8130 is from 7169. The prima facie does not appear. This court, upon hearing the parties, has heard the learned counsel for the parties and is of the opinion that instead of disposing of the instant application in a piecemeal manner, the appeal requires to be disposed of. This court is also aware of the fact that in view of the order dated 21/9/2022, the applicant herein is is not in a position to carry out any construction. Accordingly, this court fixes the instant matter on 14/3/2024 at the top of the list, so that the appeal can be disposed of at the earliest. Oh no, 18, what? 21/3/2000.
Public.
Right. Nila Naidu. No, Nila Naidu.
No.
Partition.
Wait, sir.
Hmm.
The injunction actually is, earlier, my lord, this honorable court has passed an injunction order. Despite that, my lord, they have started construction. I'm the plaintiff, my lord, the suit has been decreed and appeal also dismissed. They preferred the second appeal. In the passage of this appeal, they've started construction about the schedule length. Therefore,
Who is in possession?
they are in possession.
Suit has been decreed in your favor.
Yes. Suit was for right title interest and recovery of possession.
Not petition has been filed, let the copy may be served and it may be listed on Friday, madam, I will see.
Okay. Mr. MSA appearing on behalf of the respondent seeks for an accommodation for filing the reply.
Appellant, my lord, in this petition I am opposite.
Seeks for a accommodation on behalf of the respondent in the instant application for filing a reply. List the matter again on 1st of April 2024.
A copy may be.
I will start the court.
Apply.
May it please your lordship, there is an application for delay continuation of 44 days.
Huh?
Continuation
Dismiss for default? RSA. So delay condone.
delay con-
Okay. You notice pick steps by so and so.
Denied.
It may pay for 1 week time for filing objection about.
Mr. Okay. What was that? Who dismissed for default?
Restoration application.
I dismissed for default.
Lordship, no. Lordship, Honorable Justice speak.
When was it dismissed for default?
5/12/23.
Lordship, not on the limitation point, Lordship. The other reason is there.
What?
Lordship, the matter was taken up, brought before the honorable court by way of filing an application, and it copy was served upon them. My learned brother is not the advocate, earlier advocate. Advocate is different person.
Okay. Let us set aside this. Have the FAO and dismiss the FAO at a later time. This is an application under Order 41, Rule 19 of the application for restoration of the appeal, accompanying appeal which was dismissed for non-prosecution. this court have taken it seen the grounds mentioned therein and is of the opinion that the state grounds are sufficient. A good and reasonable grounds for restoration of the application, accompanying appeal. Accordingly, the instant application stands allowed. The accompanying appeal being FAO number 34 of 2017 is restored. The registry is directed to list the FAO. The said FAO number 34 of 2017 on 1st of April 2024 for admission. Admission no. For?
It was hearing.
No hearing. Okay. On 2nd of April 2024 for at the top of the block. Dispute. Which one? Oh, that matter? No?
No, no.
Doesn't know how to write my name. Why is he asking for review?
Petitioner have filed a review application.
Why?
Judgment and order taken. 2623.
Who is filing this? It's the matter. It's the matter on 1st of April 2020. Service not complete, list the matter after completion of the Yes, what is this? What condonation?
The abatement is not restricted. And I filed my letter for all the 3 applications.
42. Only one application has come. Huh? How many
Mine, I took
applications?
42.
Only 2 applications.
Yes, sir. Section 5 will put the limitation act.
Huh?
And my lord, the substitution. This order.
Section 5 and where's the
Order
abatement?
Order 20, my lord, it went on abatement, my lord, long abatement.
Have you filed the application under order 22 rule 9?
Yes, I filed my lord, but it has not been listed. And I have to.
Mr. T. Chaudhary submits that
there is
the
one thing,
application seeking abatement of the appeal have been filed. So, however, the same has not been listed. The registry shall inquire into the said aspect and thereupon list the matter.
Well, there is one thing, my lord, in the morning, my lord, I got the office. But the office, there is no record regarding this.
Then you didn't file.
So I'll file if there is no record, my lord, then I will be allowed to file.
Mr. Then your application for condonation of delay has gone for a 6.
My lord,
How can there be?
in the
Mr. Counsel, kindly understand order no. That your first application should not has to be for the purpose of setting aside the abatement.
I understand, my lord.
So your
Yes,
condonation
yes,
application becomes useless.
The filing advocate was my wife, my lord, the expert man. And the advocate's clerk also is not here, man. He has left the profession. And now I have it is discovered, man, that this application is not here in the.
I'm gonna let you. This is the matter of the 3 weeks. You find out what is to be done, but your condonation application has gone.
No, I'm sorry, my lord, for the situation I faced.
How much? No, you should know. Somebody is appearing?
Lordship, one thing is that Lordship, the IA for condonation, the details 703 days delay.
Then?
I have
We
seen the
dismiss it.
paragraph six. There would be control. So I filed another IA lordship, the 564 lordship.
Hello, we'll take it up on Amarati. Why there are two eyes?
Lordship, one is stay the money acquisition lordship. First IA lordship, the 424 is the honor the delay lordship.
Have you got the money?
No, my lord, we have filed the execution.
By the time this is condoned, you get the money out. This is the matter of 2 weeks.
Lordship, whatever is the next lordship that we one lordship. The
There shall not be a, should I write there? There shall not be a bar for the executing court to proceed with the execution.
yes,
Should I write?
is the proceedings lordship. Still that. Call for action.
Absolutely no. Yes, next.
44. My lord.
Hello.
Oh.
I took 41, my lord. There was an inferior order, but
What is this CRPIO? You are appearing.
No, I'm appearing in 44.
Yes, 44 letters. Yes, what is this?
My lord, the matter has already been, my lord, amicably settled between both the parties, my lord, and compromise agreement has been executed, my lord. It's execution, my lord, for, my lord, compromise agreement. I have annexed, my lord, compromise agreement, and this is joint application, my lord, both the parties.
Now, this is an application under Order 23, Rule 3 of the Code of Civil Procedure for passing of a decree on compromise. This, it has been stated, by this application, it has been brought to the attention of this court that a deed of compromise agreement has been entered into between the plaintiff and the respondents. And therein, between the plaintiff and the respondent on 21/9/2023. The said agreement contains various clauses from 1 to 7. The learned counsel appearing on behalf of both the parties submit that there has been no force or coercion employed upon any of the parties while entering into the said application agreement. Considering the above, this court, therefore, disposes of the instant appeal, the accompanying appeal being RSA number 5/2018, on the basis of the said compromise, as recorded in the deed of agreement, agreement of compromise dated 21/9/2023, enclosed as Annexure 1 to the application being IA civil number 641/2024. The said deed of compromise dated 21/9/2023 shall be a part and parcel of the instant decree. The registry shall, and the said deed of compromise is marked with the letter X, which shall form a part and parcel of the decree of this court in the instant second appeal. The instant application stands allowed, and the second appeal, being RSA number 5/2018, stands decreed in terms with the compromise as recorded above. Yes. What is this CRPIO?
yes, sir.
For what?
There was an order by the trial court ordering the governing body members of the DPS school to appear in person, whereas they were not the parties there. The principal was the party.
Okay, Ekon Diok, item number 41 to list the matter on 10/4/2024. How many respondents are there?
2.
The petitioner is directed to take steps by way of justice upon the respondent numbers 1, 2, and 3
3.
and file an affidavit of service rooted to the registry of this court and file an affidavit of service on or before the next day. In time out as far as our election continues.
All right.
कल टीवी है, कल डिवीजन है। ये सब नहीं थोड़ा इधर में ठीक ठाक करना पड़ेगा ना जगह, देख के इधर ठीक करना पड़ेगा ना।